trying to log in. I don't know what the schedule is. I know it's probably later in the day, but
Right.
why not start it up, right? Present. We were going to be instructing the jury. The jury clerk apparently told our 4 alternates who reported downstairs that they were not needed and sent them home. They're being retrieved. One of them, I'm told, is 30 minutes out, but that was 5 minutes ago. Lacey Clark. But we're also trying to get the Zoom to work on the courtroom, but that'll be working when we need it. Mr. Burns wanted to address some scheduling issues, though, which we have an opportunity to do that now since we're not ready with the jury.
Yes, Your Honor, I have run into some difficulties. I mean the defense have lost roughly 2/3 or thereabout of our anticipated penalty phase witnesses. This is due to the public nature of the trial and the attendant social media yammering about it. I have many witnesses who have been contacting me since the verdict saying I can't do it. People are saying things already. I'm going to get mean comments. I'm going to get trouble at work. People are going to look at me crosswise. It's not the type of situation that could be remedied by serving them with subpoenas and bringing them in here in this circumstance where I'm begging for a man's life. I can't have witnesses shooting daggers at me 90% of the time and spending the other 10% of the time glaring at Jose. If they don't want to be here, I cannot use them, is the practical nature of it. So my plans have been quite upset in the past few days, but I'm gonna have to work with what I have. What I have at this point is a prison expert who is available to testify remotely this afternoon beginning at 1 o'clock. He's available at any time from 1 to 5. I have a lady who knows Mr. Soto-Escalera in previous years. She, I think, can come and testify in person this afternoon. That is all I have ready for this afternoon. I do have, I believe, 4 of Mr. Soto-Escalera's family members flying down from Connecticut. I thought that they were getting on a very early flight this morning. It turns out they're not leaving from LaGuardia until 3 o'clock this afternoon. I will not have a chance to interview them and find out exactly what they are going to say and whether it will be contradictory to other people in the family as to what they have to say. There is some difference in perception between older members of the family and youngers. And so I'm not sure who of the 4, maybe all, maybe 1, maybe 2, that I will end up using. Mr. Richardson, of course, has expressed an interest in deposing these witnesses beforehand. So I'm not sure what exactly I'm suggesting there, but it's going to be a late night for me and Ms. Minton. These witnesses would presumably be available to testify tomorrow. And that's about as much as I can update the court right now.
And Judge, can we just approach for a bench conference, because I don't want the rest of this that I need to lay on the record aired on court TV.
Sure.
Thank you.
discussed here at the bench, one of the lawyers has advised me they think that one of the jurors' physical appearance was broadcast in violation of the court rule. Don't know whether that's true or not, but I do want to re-advise the media not to do that at any point, not to show the faces of the jurors. All right, so that's understood in that regard? Okay. And any word on our extra 4 alternates? We're still waiting on one. Okay. Well, let's go off the record. Let's give the Zoom a try globally as far as that's concerned. So my plan would be, based on what y'all told me, we would do whatever we can this morning with the states. The state has victim impact. Does the state have any other evidence other than victim impact?
That's all.
Okay, so we would do the victim impact. Then what would be the earliest that your prison expert or the other witness would be available?
1 p.m., Judge.
1 p.m. so that we would break till 1 p.m. do that. We would reconvene tomorrow, hoping to get those witnesses on that flew down tomorrow morning. And if you needed some extra time to talk to them briefly, we might be waiting for jurors as we were doing right now. We would do that, and then perhaps we would have the closings either later in the morning or early afternoon, and we would just go that. So it's not a major adjustment to our schedule, right? Does that sound?
Did you say closings today?
Tomorrow afternoon.
Yes, that's
Tomorrow afternoon.
fine. The only,
Doesn't that accommodate everything for the defense? I believe it does, because you have your people, they have their people flying in today, then you'd have them tomorrow, and we'd be able to do the closings tomorrow afternoon.
Oh, I could probably survive it, Judge, yes.
Yeah, why not?
so to be clear, tomorrow morning I would have an opportunity to at least speak to these folks. And
Yeah, if they're here,
They
and-
present
yeah.
their evidence, and then we just close in the afternoon. Yeah, that's fine with the state.
Yeah, so that would be the plan,
Yeah, that
to
works.
accommodate the communication snafu regarding the witnesses flying down. That's what caused us the difficulty logistically. And let's get the Zoom straightened out, though we don't have all of our 16 jurors yet. All right. I'm going to go off the record momentarily.
most of our Connecticut people will be speaking in Spanish. We will need an interpreter for that.
Okay, court certified interpreter.
And Judge, we'll need them here at 8:30 because the state intends to interview our witnesses at 8:30 in the morning tomorrow
Okay.
morning so that the interpreter can interpret for the state.
Thank you.
Let me show who's in charge of the interpreters now. But I will let Deputy Court Administrator know. It looks like you're getting in now. Yep. So what I'm going to do, Tim, I'm going to leave it on, but there will be no audio for them, but I'll just, actually, now that we're good, before we break, we'll restart it because it times out. So I'll just shut it off, but we've got the Zoom working now. Okay. Let me go off the record. We'll start.
Oh, Stan, the court will be at a brief recess, as you were.
All parties present. I think I need to tell the jurors when, they're not ready to come in yet, but when they do come in addition to re-admonishing them about the media coverage and not to talk to anyone, I should tell them there are timeline. What I think is, it's going to be a little quick this morning. We're going to have some witnesses this afternoon, have witnesses tomorrow morning, then the case will be argued to them tomorrow afternoon. Otherwise, they're going to come in here for all of that 15, 20 minutes, and I'm going to release them to 1 o'clock, and they're going to be wondering what the heck is going on and maybe start getting concerned about their own time. So if I do that, it's kind of preparing them for what's going to happen. Is that all? What I'll say is, I'm thinking of saying, because as they'll see, there's a lot of logistics involved with the nature of this proceeding. It takes some maneuvering and adjusting, and that's what's caused the situation. They shouldn't be concerned about that. But once they know, we'll have the case submitted to them tomorrow afternoon. They should be fine. All right, we're still waiting for that other juror to come up, right?
Yeah.
Okay, go off the record.
Unless-
She's there? Okay. Oh, okay. All right, so it looks like you've got a few minutes to prepare your video, audio, which you're preparing. All right, let's bring in the jury. We'll get started. All right, the jury is present. Good morning once again, ladies and gentlemen of the jury. And before we get started, at this juncture in the trial, I know that I have drilled into your heads, hopefully successfully, to be sure to avoid any media coverage of the case. Also, not to talk to anyone about the case, including your fellow jurors, although you know we're past deliberations in the guilt phase, but that rule applies now too at this time. Don't talk to each other about this point in the trial until you go back to deliberating the case. But because of the vast media attention that this case has attracted, I want to be absolutely sure to reiterate to you, although I think I've got the message clear once again, in an abundance of caution, please don't talk to anyone about the case. And I appreciate that you are following the court's instructions in that regard, so that you base this part of the proceeding only on the evidence presented in court that you've already heard in the guilt phase of the trial and that you will be hearing during the sentencing phase. Before we get started and I give you instructions about this part of the proceeding, I do want to tell you in advance, give you an idea of logistically, procedurally, how we're going to be going forward over the next 2 days. And my primary goal there is to assure you that our intent is to submit this case to you for your decision tomorrow afternoon. Cases at this juncture involve great logistical challenge that are beyond the control of the attorneys. They do the best they can, but witnesses will be called who are either at or coming from very far away places, and you all are aware of what is involved with travel. So therefore, what's going to happen this morning, we're going to have some very brief testimony this morning. We're going to break. We're going to start this afternoon at 1 o'clock. We're going to have some testimony this afternoon. And then after that, we'll break. We'll come back tomorrow morning, have some testimony in the morning. And then the goal would be to submit the case to you with arguments and instructions on the law in the afternoon where the case is submitted to you. The reason I'm telling you that is I anticipate some of these breaks could be significant beyond what we would normally have done during the guilt phase. So I just want you to be prepared for that, and also not to concern yourself with it, just to be patient. But I think it'll help you being patient if you know the grand scheme as far as when the case will be submitted to you, which is tomorrow. So I believe your participation in this matter will be ended tomorrow afternoon. That's the schedule. So now that I've explained that, members of the jury, you have found the defendant guilty of 1 count of first-degree murder of Tania Wise and 1 count of first-degree murder of her unborn child. The only issue before you in this phase of the trial is to determine the appropriate penalty as to these crimes. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. As you know, what the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you heard during the guilt phase of this trial, is presented for you to determine whether the state proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case as to both victims are: 1, as to both victims, that the defendant was contemporaneously convicted of another capital felony. This is based on the conviction as to the victim involved in the other count. As to both victims, the capital felony was committed for financial gain. That's number 2. Number 3, as to both victims, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The term cold means the murder was the product of calm and cool reflection. The term calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation, demonstrated by a substantial period of reflection, is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. And aggravating factor number 4 relates only to count 2, the first-degree murder of the unborn child, and that is the victim of the capital felony was a person less than 12 years of age. Once the state has presented evidence of the existence of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Mitigating circumstances. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, the alternate jurors will be released, and you will begin your deliberations. You should not form any definite or fixed opinion until you've heard all the evidence, the arguments of the lawyers, and my instructions on the law. Once again, until that time, you should not discuss the case among yourselves or anyone else by any means whatsoever. Your decision must be based solely on the evidence or lack of evidence and the law. The same rules and procedures regarding your possession and use of cell phones apply to this phase of the trial as well. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room, and you cannot have in the jury room any cell phones, computers, or other electronic devices other than those that we would provide to you as we did in the guilt phase. Once again, you must not conduct any investigation of your own. The same rules continue to apply. Just as in the guilt phase of this case, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence, and the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. We now begin with the opening statements of the attorneys, and the state may proceed with its opening statement.
Morning, everyone. All right, so as you've already found the defendant guilty of first-degree murder of Tania Wise and first-degree murder of what would be her second son, the defendant's fifth child, Josiah Wise. And as the judge just explained to you, all of the evidence that was introduced during the guilt phase applies in the penalty phase. So all of the evidence that you learned, all of the testimony, that all applies in this case, and if you need to bring it, it'll go back with you again if you need it. So what is the first step that we talked about? And this goes back to jury selection. The state has to prove each of the aggravating factors beyond a reasonable doubt. And what you'll see when you go back and you think about the evidence that from the guilt phase applies to this case is that has all been proven. Each one of those have been proven by beyond a reasonable doubt. And the judge talked to you about 4 different factors. 3 of them apply to both victims. And when we talk about both counts are independent of themselves. The defendant can get a death sentence on both counts. He can get a death sentence on one or the other. He can get death for first-degree murder of an unborn child, or he can get the death sentence on just Tania Wise. He can get life on both counts. That's your decision. But what the evidence that was presented in this case already shows is that each and every one of those aggravating factors has already been proven beyond a reasonable doubt. And when you use your common sense, it's pretty clear. Because what's the first one? Contemporaneous, there's a capital conviction. Both of the murders you've already found him guilty of. That's what that factor is. It's been proven you've already found him guilty of both murders at the same time of both the victims. That factor's been proven beyond a reasonable doubt. What's the next one? Financial gain. How has that been proven? He told us in the garbage truck, I'm going to lose everything. I'm going to lose it. He needs to stop this before he has another child. It's going to ruin his marriage. It's going to cost him money. There's a potential for there to be a separation. He's got a new child to take care of. He wanted to eliminate the possibility of his wife finding out and the existence of him having another child. He did this for a financial gain. He tells Eric Alvarado days and times over and over again, what is his situation? It's been proven beyond a reasonable doubt. The fourth one that applies to just the victim, once again, you use your common sense. You think about this, the victim was less than 12. We know the gestational age of the baby. She was 8 months pregnant. Once again, the evidence that's already been presented in this case proves that beyond a reasonable doubt. So when you go back there, the first step should be those three easily proven beyond a reasonable doubt. What is the last one? It was done in a cold and calculated and premeditated. And the judge, he defined those to you. Cold is a cool, calm reflection. Let's go back to the garbage truck video. He planned this out for days, over and over again. He drives around in his garbage truck discussing, should I do it this way? Should I blow her brains out? Should I choke her? Would it be easier to get it done with one blow and be done with this? They look at many different spots of where he's going to dump the body. Is anyone going to find her out here? He thinks about what her life is like. No one's going to be looking for her. He talks about how he's going to lure her out there. It's all been proven beyond a reasonable doubt. Any one of the four aggravating factors in and of itself can justify the death penalty if you go through the whole process and you follow the laws instructed by the judge. All four of them can, but each one is independent of itself, and the first step is, do you find that there are aggravating factors? And the evidence shows yes, all four of them are there. Now, do those aggravating factors justify the death penalty? Yes, I encourage you that they do. And when you go back and you look at all of the evidence in this case, you look at the aggravating factors, you consider the mitigating circumstances, the appropriate sentence is the death penalty in this case. Thank you.
Thank you. And the defense is in a position to make an opening statement at this time. Mr. Burrows.
Thank you.
Thank you.
Ladies and gentlemen of the jury, good morning. Good morning. I have waited long to address you, but more about that later. The state will, I think, likely prove, probably already has, that this killing was done coldly and calculatedly and premeditatedly. I think they're going to prove that to you. So I think you probably will have an aggravator in your pocket. And I think regarding the victim, Josiah, who looked in the autopsy photos so much to me like a newborn baby, I think you're certainly going to find that he is under the age of 12. And this is the opportunity where I will tell you what the mitigators will be and what my witnesses will be and who they will be and what they will say. And I would love to tell you all about it, but I don't know. Since the conviction, many of my witnesses have melted away. They won't be here. Victims of their own moral cowardice, in my opinion. I could compel their appearance by subpoena, but I'm here to beg for a man's life, and I don't want people in the witness chair who don't want to help me do that. So I can't tell you exactly what's going to happen beyond this afternoon. This afternoon, I will present a witness. His name is Raul Banasco. He is an expert in prisons, in the Florida prison system. He's worked in Florida, he's worked in other states. And he will tell you about the prison system and how Jose will fit into it. If you do vote to condemn him to death, I think your knowledge and common sense tells you that he will exist as a prisoner for years until that happens. And if you should vote for life without possibility of parole, then he will exist in prison forever and ever. And Raul Banasco will tell you how that might be, so that you have a fuller picture there. You will also hear from a lady who knew Jose a long time ago, knew him well, knew him intimately. She will come in and testify. She, at least, is not afraid of what people on social media might say about her. She will come in difficult circumstances and tell you a little bit more about Jose. That's all I have for this afternoon. The judge mentioned travel problems. That's my witnesses. We have a problem wrangling them and getting them here from Connecticut. I do expect that we are going to have some of Jose's family members arrive this afternoon in Palm Beach. We will speak to them this evening. The state will have a chance to speak to them tomorrow, and you will hear from one or two or three or maybe all four of them tomorrow. I'm not sure how many are actually going to get on the plane. And so I don't want to leave you in a mystery. I wish I could tell you who's going to be here and what they're going to say, but you and I will learn together probably. But the thrust of the matter is that you will have plenty of mitigators to consider. And because I am missing witnesses, will probably alter and enlarge some portions of my intended argument that will be addressing what it might mean to you and how you will make your moral decision. As you have learned in jury selection, it's your own personal moral decision. I'm going to offer you, how about that, some guidance in that way. So you will hear some witnesses for the defense this afternoon. I think you will hear from some of Jose's family members tomorrow. And then I think you're going to be making your decision or retiring to deliberate about it at some point tomorrow. That's all I have for you right now. Thank you.
Thank you, Mr. Burns. And the state may proceed with its case.
Yes, sir. The people of the state of Florida call Elizabeth Bedolla.
Can you stop right here, raise your right hand and face the clerk?
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Over that with you, understand?
Good morning.
Good morning.
You've testified before, but go ahead and state your name for the record and spell your last name, please.
My name is Elizabeth Bedolla. It's Bedolla.
Okay. And again, just for the sake of clarity, go ahead and state your relationship with Tania Wise.
Tania was my daughter.
Okay. And did you prepare a written victim impact statement?
That's correct.
Okay, I'm going to show you what has been marked as Court's Exhibit Number 1. You recognize this statement?
Yes.
Is that the statement that you prepared for the jury today?
Yes.
Okay. When you feel like you're ready, please go ahead and read that statement to the jury.
My name is Elizabeth Bedolla, and I am the mother of Tania Wise and the grandmother of her unborn son, Josiah Thomas Wise. I am here to speak about the loss of my Tania and Josiah and how their death has forever changed my life and my family's life. Tania was lovable, caring, a devoted mother. She had a beautiful soul and was always willing to help and take care of her family. She enjoyed being a mother more than anything in the world. She loved spending time with her son Jamar, playing with him, cheering for him in all his events, and making sure he always felt loved and supported. Tania was so excited about becoming a mother again. She always spoke about giving birth and how great of a mother she would be once more. She had so many dreams for Jamar and Josiah, dreams of raising them, guiding them, creating happy life together. Those dreams were stolen from her, from us, from the child who will never have a chance to grow up with his loving mother. Every memory with Tania was special. I clearly remember the last time we were together as a family. Her stepdad, her son, Tania, and I went to the beach. We laughed, we played, we had so much fun. It was one of the happiest days we had together, and I will cherish it forever. Another beautiful moment that I remember was her baby shower, surrounded by family, celebrating new life that we were waiting for to welcome. Those were the last 2 times we had with Tania. That were memories I will hold on in my heart for the rest of my life. The emotional impact of losing my Tania and Josiah is unbearable. I cannot sleep at night. When I do, the nightmares are horrific. Birthdays, holidays, and even simple dinners bring so much emptiness, loneliness, and pain because she's not there. I'm unable to function properly at work or in my daily life. I miss her so much, my baby girl. She was my baby girl, my only girl. And losing her has broken me in many ways I cannot explain. The grief is overwhelming. I live in constant pain, not only in my body, but also in my heart. A heart that never goes away. It never goes away. I'm angry. I'm angry because I don't have Tania and Josiah here with me to love and joy and share my life with every day. They should have been here. Instead, I'm left with grief, sadness, and memories. That anger is part of my pain, and it will never leave me. I still have problems accepting that she's gone. I catch myself thinking that she will be here with us tomorrow, and that I hear her voice or see her smile. But tomorrow comes, and she's still not there. That reality is crushing, and it's something that I struggle with for the rest of my life. Her son, Jamar, who was only 8 years old at the time of her mother's murder, misses his mom every single day. The sadness and the trauma that this has caused him is something no child should ever have to carry. Jamar struggled with the loss deeply, and it breaks my heart to see him growing up without his mother's love, guidance, and presence in his life. Our house was one full of laughter and energy, and it's now quiet. Tania was the life of our home, with her smile, her joy, and the way she played all around with Jamar. Now the light is gone, and our home feels dark and empty without her. The pain is not mine alone. Tania's stepfather, her son, brothers, grandparents, aunt, uncle, and cousins are all suffering as well. Many of us are battling depression, trauma, PTSD because of this tragedy. Our entire family has shattered, and the weight of the grief follows us every single day. The stress of losing Tania and Josiah has also affected my health. I have heart condition. It has grown worse because of the grief and the stress I carry every day. This tragedy has taken serious toll on my body, broken. It has also broken my spirit. And it's not just me. It has also taken physical and emotional impact on our son, Jamar. I grapples daily with the loss of Tania, his mother. I wonder how the future will be. And I wonder how Jamar will grow up without his Tania. And how our family will find a way to live with this emptiness. Nothing feels certain anymore without her. The future we imagine is gone, and we're left trying to survive in a world that feels hopeless and broken. Tania has already missed so much, and she will continue to miss every important milestone in Jamar's life. She will not be there for his accomplishments, his graduation, even his wedding day one day. She will never get a chance to hold her grandchild. These are moments that should have been hers as a mother, but they have been stolen from her and from all of us. Nothing can bring Tania and Josiah back. The future we dreamed of, the milestones, the celebrations, the simple everyday moments have been stolen from us. I will never see my daughter raise her children. I will never see my daughter raise her children. And I will never get to hold my grandson. Our loss is permanent. And it has changed me and my family forever. The death of my pain and devastating impact of this crime has had on me and my family the most important, but most importantly, my grandson, who will now become into a life without a mother, is simply unfathomable. We will live with this grief for the rest of our life. What happened to my Tania and Josiah will affect me forever. And I don't know how to live without her. She was my baby girl, my only girl. I will carry this pain every single day of my life. Nothing will ever take away this grief, the anger and the emptiness that their loss has left me behind. In the end, 2 innocent lives have been stolen from us, and we will never fully recover from this loss.
Ma'am, I want to show you what has been marked as court exhibit, photo composites, court exhibit number 1. Are these 30 photographs of Tania that show her throughout her life?
Yes.
And do all these photos show Tanya at various stages of her life?
Yes.
Your Honor, permission to publish?
Any objection to introducing the item and publishing it?
No, Your Honor.
Those items will be introduced into evidence and published. And you may step down. And the state's next witness.
Yes, sir. The people say the Florida called Tracey Hammel. Tracey Hammel.
Let's see. Hold on.
Tracey Hammel.
Does she need to be sworn?
I don't know what you're I don't know who the witness is or what your plan is, so it depends on.
Victim advocate who's going to read several victim impact
Okay,
statements.
so I'm not, she would not be sworn at this time. She's going to simply be reading a statement of another person, okay?
Yes, sir.
It's not sworn testimony. She can simply read the document.
Ma'am, can you state your name for the record and spell your last name?
Tracey Hammel, Hamel.
Okay, and what do you do for a living?
I'm a victim's advocate at the state attorney's office.
Okay, and as part of your duties as a victim's advocate, do you sometimes read prepared statements for those people who may not be in an emotional position to do so for themselves?
Yes.
Okay, I'm going to show you what has been marked as Court's Exhibit Number 2 for identification purposes. Do you recognize this?
Yes.
Okay. What is that?
This is Lenora Bedolla's victim impact statement.
Okay. Can you go ahead and please read that to the jury?
Yes. My name is Lenora Bedolla. I am Tanya's stepsister, as well as her best friend. I am here to speak on behalf of myself, my family, and the loss we have all suffered since Tanya and her unborn child Josiah were taken from us. Tanya was a loving mother, a hard-working woman, and a bright light in all of our lives. She had an incredible sense of humor that made everyone around her feel at ease. She was so smart and resourceful, always looking out for others and putting them first. But above all, Tanya was my safe person. She was the one that I could confide in, the one who always knew how to make me laugh or comfort me when I was struggling. I told her everything, my joys, my worries, my fears. Not being able to speak to her anymore has left a hole in my heart that nothing can fill. Since her death, I have cried every day. I wake up with the ache of her absence, knowing that my kids will never get to spend time with their TT Tiny. We won't be able to go to the beach together again or share simple moments like going to the mall or eating out with our kids. I moved to Florida for the summer just to be closer to her, hoping we could make more memories, and now I'm left with the empty space she once filled so effortlessly. The pain of not having her here is unbearable. I miss the small things, the smell of her hair when she got out of the shower, her smile, and the warmth of her hugs. These are things I will never get to experience again, and it hurts more than I can express. Life is not the same without Tanya. It will never be the same. There is a constant weight of sadness in everything I do, and I feel lost without her by my side. She was a part of my everyday, and now that part is gone. This profound loss that has shattered our family. Tanya was not just a victim of this crime. She was a daughter, a mother, a sister, and a friend. Josiah, her unborn child, was a life we all looked forward to, and his loss is felt deeply. We are left behind with an emptiness that words can barely capture. I will carry the pain of losing Tanya with me for the rest of my life, but I will also carry the love she gave. She was taken from us far too soon, and nothing will ever fill the void she has left.
Thank you. I'm going to show you what's been marked as Court Exhibit Number 3. Do you recognize this document?
Yes, I do.
What is that?
This is the victim impact statement from Michael Reveron.
Okay. Can you go ahead and please read that when you're ready?
Yes. My name is Michael Reveron, and I am the proud older brother of Tania Wise. Tanya wasn't just my sister. She was one of the strongest, most caring people I've ever known. She had this rare gift of being the life of the party wherever she went. Her laugh was loud, her smile was real, and she had a way of lighting up a room just by walking in. But beyond all the fun and energy, she had a heart full of love for her family and friends. Even though I was the older brother, Tanya always acted like she was my second mom. She looked out for me in ways I didn't always notice at the time, but I feel every day now. She would show up at my job just to take me out to lunch. She would also come to my job just to spend time with me, sometimes staying for hours just to talk, laugh, and be together. She always offered support, encouragement, or simply a listening ear whenever I needed it. Some of my favorite memories are the simple ones. We used to go to the movies together, just me, Tania, and my nephew Jamar. We'd laugh, share snacks, and just enjoy being around each other. That was our thing. It was peaceful. It was fun. Birthdays and holidays still feel empty, even after all these years without her laughter and presence. What used to be moments of joy are now constant reminders of what we have lost. Losing Tania has left me broken in ways that are hard to write. I feel anger, sadness, and emptiness all at once. I feel like a part of me is missing. I struggle to focus and to move forward because so much of my strength and happiness came from her. Even as her older brother, she made me feel grounded. Some days I find myself grabbing my phone, trying to call her to tell her about my day. On top of the grief, I now live with PTSD, depression, anxiety, and nightmares because of what happened to her. I relive the pain over and over in my mind, and some nights I wake up shaking and crying. It has taken a serious toll on my mental health, my sleep, and my ability to function day to day. The future has been forever changed without Tania. I think about all the milestones she will never get to experience. She will never see her nieces and nephews grow up or witness all the things they will accomplish. She will never meet her grandchild. She will miss the wedding we always joked I'd never have. I will never get to meet my unborn nephew or see all the great things he would have done. For me, I will never again have my sister, best friend to share memories with or to laugh with. Her absence leaves a void in my life that can never be filled. I hope that by sharing who Tania was and how she lived, that the court understands the depth of loss. We're not just grieving her absence, we're grieving everything she would have continued to be: a loving mother, a joyful sister, a loyal friend, and a light in our lives. This isn't just about the life that was taken from Tania and my unborn nephew, but the lasting impact their loss has had on me, my family, and all who love them. No words can fully capture the pain, emptiness, and grief we carry every day. Depth of our loss knows no bottom or end.
And I'm going to show you what has been marked as Court Exhibit 4. Do you recognize this document?
Yes, I do.
What is that?
It's the victim impact statement for Reyes Bedolla.
Okay, and when you're ready, can you go ahead and read that quickly, please?
My name is Reyes Bedolla. I am the stepfather of Tania Wise and the grandfather of her unborn son, Josiah Thomas Wise. I would like to talk about how much I miss them and how hard it is to live without them. Tania was amazing, funny, helpful. She was a bundle of joy. She was a loving, caring, and devoted mother who loved to play around with her son. Everywhere she went, she would smile. She was always there giving a helping hand to the family. She touched everyone with her kindness. We had built a strong bond. I knew her dream and what she wanted to do with her life, and I was going to be there every step of the way to support her. Her life was about her children and raising them. Losing her in this way has left me with a pain that never ends. I looked forward to welcoming my grandson, Josiah, into the world, but am now heartbroken as I have to come to terms with the fact that this will never happen. All I am left with are dreams of what he would be like today. Every time I see somebody else with a child, I imagine my beloved grandson and wonder about the things that could have been. I would have loved to watch Josiah take his first steps, play sports, and grow into a man. I will never hold him. play with him, or even spoil him, and he will never call Grandpa. I am so hurt my life will never be the same. I am raising Tanya's son Jamar, and I see how he suffers for his mother. This emptiness that my family and I can never be filled. I ask myself, why are Tanya and Josiah? We struggle to move forward every day. I remember going to the beach with my wife, Tanya, and her son Jamar. It was all about spending quality time together, and we all planned our future. Our conversation were all about family. I don't have this anymore. I have never been able to go back to a fun day at the beach, as our family feels like we are not complete and are broken, and we are trying to piece it together to continue our next day. Our family is struggling to move forward while trying to honor their memory. Nothing will ever be the same.
Thank you.
You're welcome.
Thank you. And the people of the state of Florida call Johnny Reveron.
So if you raise your right hand and please support.
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Witness stand.
Morning.
Good morning.
Can you state your name for the record and spell your last name, please?
Yes, it's Johnny Reveron. Last name's Reveron.
Okay, and did you know Tania Wise?
Yes, she was my sister.
Your sister, okay. I'm going to show you what's been marked as court exhibit number 5. Do you recognize this?
Yes, sir.
Okay, is that the statement you prepared?
Yes, sir.
Okay, when you're ready, go ahead and read that to the jury.
Yes, sir. My name is Johnny Reveron. I am Tanya's older brother. I stand before you today to speak not only for myself, but for my family and for Tanya's unborn child, who was never given a chance at life. The loss of my sister has devastated every part of my life. Tanya was not just my sister. She was my friend, a piece of my heart. She was carrying her child with such joy and anticipation. That child should be here with us, loved and cherished. But this life was taken before it even began. Just a month before this tragedy, Tanya and I spoke after she started working at the same company where I work. We talked about her excitement for this new chapter and how much she was looking forward to building her future. I never imagined that it would be one of the last meaningful conversations I'd have with her. Since her murder, my world has been turned upside down. I wake up every day with a heavy heart, knowing I may never hear Tanya's laugh, see her smile, or share the simple everyday moments that brothers and sisters are supposed to have. Holidays, birthdays, and family moments are now filled with pain because Tanya and her baby should be here with us. This tragedy has not only caused unbearable emotional pain, it's left lasting scars on my family's sense of security, stability, and peace. I struggle with grief, anger, and unanswered questions. I have lost sleep. I have lost hope. And I will carry this pain for the rest of my life. Tanya and her baby deserve to live. They deserved a future full of love and opportunity. Instead, what remains is a permanent void in my heart and in my family's life. Thank you for allowing me to share on how much I miss my sister.
Thank you. Thank you, sir. Thank you. People in the state of Florida call Yaritza Irizarry.
Ma'am, if you could just raise your right hand and please support.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And for the witness.
Morning.
Good morning.
Can you state your name for the record and spell both your first and your last name, please?
Jaritza Irizarry, Jaritza. Last name Irizarry.
Okay. And did you know Tania Wise?
Yes, she was my niece.
And I'm going to show you what has been marked as court exhibit number 6. Do you recognize that document?
Yes, I do.
Okay, is that the statement that you prepared to deliver to the jury?
Yes.
Okay, when you're ready, go ahead and read that to the jury, please.
Your Honor, my name is Jaritza Irizarry, and I am the aunt of Tania. To me, she was more than a niece. She was like a daughter. Tania was beautiful, loving young woman whose life was taken from us in the most painful and senseless way. Her death has left us a permanent hole in my heart and in the heart of my family. Tania was a devoted mother. She loved her son Jamar with everything she had, and she was overjoyed to be pregnant with another baby Josiah. Not long before her murder, I hosted her baby shower. I could still picture that day, glowing with happiness, surrounded by her family, smiling as she opened gifts for her new baby. She was so full of hope for the future, so excited about raising her children, and so ready to begin a new chapter of her life. But that joy and that future were stolen from her, from Jamar, from all of us. Jamar has to grow up without his mother, and Josiah never even had the chance to take his first breath. Her loss has shattered our entire family. My sister, her mother, is broken. No parent should ever have to bury their child, and watching her live with this pain has been unbearable. Every holiday, every birthday, every family gathering feels incomplete without Tania. There is always an empty chair and a silence where her laughter should be. For me, it's the everyday moments I miss the most. We shared so many simple joys together, taking the kids to the beach, going shopping, eating out, or just cooking her favorite meal. I miss sitting with her, talking and joking around. She had this way of making everything seem better. No matter what I was going through, at times I wanted to pick up the phone and call her to tell her everything, like what I always did. But now there is only a silence. Those ordinary times that once brought me comfort and happiness now feel heavy and empty without her. The pain of losing Tania has affected me deeply, both emotionally and physically. I cry without warning. I struggle to focus to find joy in the things I once loved. I suffer from sleepless nights, nightmares, and anxiety. The grief sits in my body like a weight, leaving me exhausted and drained. A part of me died with her, and I will never be the same. The crime didn't just take one life, it took two. Tania's life was taken, and so was baby Josiah's before he ever had the chance to live. Jamar lost his mother, my sister lost her daughter, and I lost someone who was like my own child. Our family has been torn apart, and the pain we carry will never go away. Respectfully, Jaritza Irizarry.
Thank you. Thank you, ma'am.
Thank you.
And people will say Florida called Jamar, Bedolla, Wise.
So if you can raise your right hand, please.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Hand over that way to witness.
Morning. Can you state your name for the record and spell your last name, please?
Jamar Bedolla, Bedolla.
Okay. And what is your relationship to Tania Wise?
She was my mother.
Okay. I'm going to show you what has been marked as Court's Exhibit number 7 for identification purposes. Do you recognize that?
Yes, I do.
Okay, is that the statement that you prepared?
Yes.
Okay. When you're ready, can you go ahead and please read that to the jury?
Hello, I'm Jamar, and I'm the son of Tania Esther Wise, who was taken from us. My mother was the closest person to me, and she was like my best friend. Also, she was always there for me. I'm here to share a few to honor my mother and talk about how I was affected. Ever since that day, Ever since that day, there have been many different ways that I've been affected emotionally. For example, I've developed depression, sleeping problems, and anxiety. Losing her made me grow faster than I should have. I used to hide my pain and try dealing with it on my own, and to protect myself from getting hurt more than I was, and I didn't like talking about what was wrong with me. Every day, I think about how she won't be able to see what I've accomplished and what I will accomplish in the future. She's already missed some of my milestones that I've reached, and I think that she would have been proud of them. I wish that she could have met my first girlfriend and watched me perform in my musical performances for my school. I'm in marching band. My mom was also musically inclined. She played the clarinet, and I hope that she would be proud of who I've become. On that day, I've lost more than a mother. I also lost the chance to have my mother watch me grow, and I hope that she's proud of me for coming here and talking about how this has affected me. I choose to honor my mother because she was one of the most, if not the most important people who has been in my life.
Thank you. That will conclude the evidence from the state.
Members of the jury, that concludes the state's part of the evidentiary portion of this penalty phase. As I mentioned, we're going to break at this time till 1 o'clock. Please remember the rules regarding communication. Don't discuss this case with anyone, including your fellow jurors. Enjoy your lunch, and we'll reconvene at 1 o'clock. And please leave your notes on your chairs.
Do I have something? I know the state for the photos composite was 1, but I already had a 1. Can this be 1A? Can I make this 1A?
What was one?
1 was, her, Ms. Bedolla's, statement, impact statement.
Yes. We're going to make the 1A. Now, some of these items I think came into evidence, but some were just court's exhibits. Is that right?
Yeah, all of them.
They're all court's exhibits. So, what I mentioned before, as far as the other one coming into evidence, just strike that. They'll all be court's exhibits. Okay. All right. And anything else for us to take before we break and come back at 1 o'clock?
Not from the defense, Judge.
Okay.
Nothing from the
State.
state.
All right. We'll see you at 1 o'clock, and we have the Zoom working. I emailed you the message about the interpreter being here tomorrow. She's going to be here, Miss
Thank you, Judge.
Bedolla, so that should not be a problem at 8:30. And enjoy your lunch. We'll see you at 1 o'clock.
All of these was admitted.
weight, leaving me exhausted, drained. A part of me died with her, and I will never be the same. The crime didn't just take one life, it took two. Tania's life was taken, and so was baby Josiah's before he ever had the chance to live. Jamar lost his mother, my sister lost her daughter, and I lost someone who was like my own child. Our family has been torn apart, and the pain we carry will never go away. Respectfully, Tracey Rosario.
Thank you. Thank you, ma'am. Thank you.
And people will say Florida called Jamar, Bedolla, Wise. So if you can raise your right hand, please.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Yeah, over that way to witness.
Morning. Can you state your name for the record and spell your last name, please?
Jamar Bedolla, Bedolla.
Okay. And what is your relationship to Tania Wise?
She was my mother.
Okay. We want to show you what has been marked as Court's Exhibit number 7 for identification purposes. Do you recognize that?
Yes, I do.
Okay, is that the statement that you prepared?
Yes.
Okay. When you're ready, can you go ahead and please read that to the jury?
Hello, I'm Jamar, and I'm the son of Tania Wise, who was taken from us. My mother was the closest person to me, and she was like my best friend. Also, she was always there for me. I'm here to share a few to honor my mother and talk about how I was affected. Ever since that day, there's been many different, ever since that day, there have been many different ways that I've been affected emotionally. For example, I've developed depression, sleeping problems, and anxiety. Losing her made me grow faster than I should have. I used to hide my pain and try dealing with it on my own, and to protect myself from getting hurt more than I was. And I didn't like talking about what was wrong with me. Every day, I think about how she won't be able to see what I've accomplished and what I will accomplish in the future. She's already missed some of my milestones that I've reached, and I think that she would have been proud of them. I wish that she could have met my first girlfriend and watched me perform in my musical performances for my school. I'm in marching band. My mom was also musically inclined. She played the clarinet, and I hope that she would be proud of who I've become. On that day, I've lost more than a mother. I also lost the chance to have my mother watch me grow, and I hope that she's proud of me for coming here and talking about how this has affected me. I choose to honor my mother because she was one of the most, if not the most important people who has been in my life.
Thank you.
That will conclude the evidence from the state.
Members of the jury, that concludes the state's part of the evidentiary portion of this panel.
Okay, as you just heard the judge say, that concludes the state's presentation of their witnesses. They're going to take an extended break here, so it gives us an opportunity to bring in our guest for this hour to discuss. Joining us now from Los Angeles, California, trial attorney Krista Ramey. Krista, thank you so much for seeing us this morning and watching this case. And you know, it's a heavy morning when you hear the victim impact statements from the family and how this tragic incident affected them, especially the young son that just spoke. He was only 8 years old when his mother was murdered.
Yeah, I remember being with you last week while we were listening to those tapes, right, of basically the plotting and the planning of her murder, and listening now to the impact that all of that had on the family. It brings it full circle for this jury, I think. And it really shows the significance of what that evil plot was and how this really impacted this family. You know, I appreciate that some of those statements had to have been read by a victim impact witness, but oh my God, the bravery of her son to do that. I think that that is going to play a big role in Florida. Remember, in Florida, for the viewers that might not remember, but after the Parkland shooting and the surprise not failure to convict or failure to sentence to death. Florida changed their law. They only need 9 of 12 now to get a death penalty conviction. So this is not going to be that hard a stretch, I don't think, for this prosecution to get over that finish line. And when you look at the defendant as he's listening to those statements, Court TV is doing a great job by showing that just juxtaposition, and he does not look affected by it. And so it makes him look more cold and calculated, I think.
Yeah, I mean, you have to wonder what he is thinking as he's listening to these statements and then knowing what's to come. I mean, we don't know what the jury is going to recommend, but when you hear the state's opening, the aggravating factors do appear to be present. Obviously, the jurors have to agree and make that decision, but then they have to take that next step to decide if, even though they are present, do they want to recommend this man, Jose Soto-Escalera, to be put to death?
So when we're picking a jury at the very beginning of a trial, one of the things that we do is we try to make sure that we have a jury that is right for every particular case that we have. And in a death penalty case, there is, extraordinary lengths that are gone through to make sure that you have that death qualified panel that you have before you. So you already have gone through one step and have gotten a panel that doesn't have those moral or, strong Catholic dogma, those beliefs that all life is sacred and the death penalty is never appropriate. So you've already kind of weeded out those people at the beginning of the case before a piece of evidence has been heard. So you've got a jury now and you've got rid of the jurors that will all be like, well, no matter what, hang them, The extremes on either end are gone. So now you do have that jury that's, kind of more, hopefully more deliberate and less biased. But they are a jury that will and have said that they have no problem issuing the death penalty if the facts are proven. And I think that the prosecution has proven their facts and elements here.
I would think that would be the case, but it's gonna depend, Krista, because the jury makeup, and I covered that one case in Texas, and that was clear. It was that Border Patrol agent. Same kind of situation. Mistress murdered her, and the little baby there was, I think, 3 or 4 years old. This one was not born yet, but about to be born, and they did not recommend the death penalty there. So it's going to be interesting to see what the jurors here decide. I mean, I don't know. We're going to take a quick break, Krista. Thanks so much for your insight on this case. And coming up, we are going to switch gears. We're going to head to Mississippi for our newest live trial. This one is the plotting parents murder trial. And we'll have those opening statements. That's coming up next after the break. Stay with us.
8.5 months pregnant, a young mother found brutally murdered.
To lose a child, there's no words for it.
Now the victim's boyfriend, a married father of 4.
Guilty of first-degree murder in the death of his mistress, as well as their unborn child.
That's one of the things that struck me. He was not remorseful.
Court TV takes you inside the South Florida courtroom
where jurors will decide if he will be put to death.
The pregnant mistress murder trial, penalty phase. Live coverage today, only on Court TV.
Turning now to Mississippi for our other live trial. This one is called the Plotting Parents Murder Trial. Jeffrey Spence is accused of fatally shooting his daughter's boyfriend, Kirby Carpenter. This was back in 2022. Prosecutors say that Spence and his wife Karen had been staying with the couple after they welcomed a baby girl. But right before they left town, Spence allegedly robbed and then shot Carpenter. Before we get you into court, here's Court TV anchor Ted Rowlands with more on this case against Jeffrey Spence.
It's a case of family ties, money, and murder. Prosecutors say Jeffrey and Karen Spence, a couple in their 60s, plotted with their daughter, Caitlin, to kill her boyfriend, Kirby Carpenter. WTVA News spoke with one of Carpenter's friends.
Kirby was a very good person and a loving person. And for someone to take that from his kids is very sad.
You've had to like him. I don't know of anybody who wouldn't like him.
Carpenter was last seen alive on November 30th, 2022. But it wasn't until December 2nd until Caitlin called 911 to report his death. She told police she found his body behind the garage of their home, hidden under a curtain and behind a toolbox. Police say he'd been shot and then dragged from a carport. According to Carpenter's family, he always carried a bag with about $300,000 in cash, silver, and gold. That bag was never found. A year after Carpenter's murder, his mother discovered a bag of silver coins in a car tied to Jeffrey Spence. Jeffrey, Karen, and Caitlin were charged with murder, grand larceny, and conspiracy. Earlier this year, Caitlin struck a deal with prosecutors, pleading guilty to accessory after the fact. She agreed to testify against her parents in exchange for a suspended 20-year sentence. And then, just days before going to trial, Mom, Karen, pled guilty as well to accessory after the fact to grand larceny for a suspended 10-year sentence.
Well, let's get you into court now for this one. This is the start of the state's opening statement.
You're the trial of that. That means you're going to hear all of the evidence presented by the state and the evidence presented by the defense. You are the judge of the witnesses' credibility. You determine if they're credible or not. I expect that you're going to hear evidence from the state in the form of testimonial evidence. You're going to hear from law enforcement officers from Tippah County. You're going to hear testimony from Smith County, Virginia Sheriff's deputies who work on this case. You're going to see physical evidence. You're going to see phone dumps. You're going to see other documents and other physical evidence in this case. Based on all the evidence, you literally take all that into consideration and apply it to the law as the judge will instruct you to get the case. First question is, who is Kirby Carpenter? That's why we're here. He died on November 30th of 2022. He was the father of 2 children, Towns and Enola. He was a son to Maddie Jane and Jerry. He was a brother to 2 sisters, Casey and Wendy, and a brother to 3 other brothers. He was a Marine Corps veteran. He was a musician, an outdoorsman, an entrepreneur, a business owner. He owned a company called Mississippi Gold, Silver, and Coin Exchange in Ripley. I think the testimony is going to be that he was a self-made man, and by all accounts, he was financially successful. He was only 36 years old when he died. Kirby was gunned down with a shotgun in his carport at his home on County Road 600 in Tippah County on November 30th of 2022, approximately 7 p.m. He suffered wounds to his neck and chest. The physical evidence will show that his body, after he was shot, was dragged from the carport to the side of the house, at which time a curtain or a tarp was placed over him, secured by a toolbox out of a pickup truck. We will prove that the person responsible for this murder is Jeff Spence, the man sitting right over there. What was his motive? It's an old story. Money, greed. Now, Caitlin Spence is the daughter of Jeff and Karen Spence. She moved to Mississippi to attend Mississippi State University, and when that ended, she moved to Boonville to work at Tractor Supply. Kirby owned a liquor store in Boonville that was close in proximity to the Tractor Supply, and they met. They started a relationship. They moved in together. In 2021, Caitlin became pregnant with Enola. She was born in July of 2022. I believe the evidence will show that Caitlin's parents, Jeff and Karen, came to Mississippi to help with Enola in July of 2022. The Spences lived in a little town called Saltville, Virginia, which is in southwest Virginia. Now, throughout this case, I want you to pay attention to the timeline. The timeline is critical in this case. The families spent Thanksgiving together in 2022. The evidence will show that the Spences, Jeff and Karen, left on November 29th, early in the afternoon, one day before Kirby's murder. On November 30th, Caitlin got up early to go to work. Kirby was still asleep in bed. Caitlin got up and she drove her daughter Enola to her friend Bailey Reese's house in Boonville for her to keep while Caitlin was at work. And throughout the afternoon, you'll see that Caitlin and Kirby exchanged text messages. Kirby's last text, the last communication from his phone, was at 6:37 p.m. on November 30th. He had been to Kroger in Corinth, and the last text, he was passing Gino's tire store in Boonville. Caitlin asked him, where is he? He's at Gino's. He's headed home. It's probably about a 10 to 15 minute drive from Gino's in Boonville to Kirby's home on County Road 600. So he's going to get home about 7 o'clock. And again, critical to this is there are no more communications coming from Kirby after 6:37. You've got people trying to text him. You've got people trying to call him with no response. So he goes dark after 6:37. The remainder of the night, November 30th, Caitlin is texting him, where are you? Apparently they've been in some kind of tiff. Argument, weren't getting along, and she's, trying to get him, okay, I'm going to bed. This continues the next day, which is on Thursday, which is December 1st, 30 days in November. Where are you? I need you home, et cetera, et cetera. No response. Again, there's no activity on Kirby's phone. This continues to the 1st and up until 12:30 on the 2nd. Which is a Friday. At 12:30, Caitlin discovered Kirby's body underneath the tarp and the toolbox. She was on the phone with Maddie Jane, who is Kirby's mother, and she called 911, and the investigation ensued from that point. When Caitlin arrived home on the night of the 30th, Kirby's truck was in the driveway. It was locked. The groceries he had purchased from Kroger were still in there, but no Kirby. So, according to Karen and Jeff, they came back to Mississippi on Saturday, December 3rd. The funeral was December 17th of 2022, and they went back to Virginia, all three, on December 20th. The investigation by the Tippah County Sheriff's Department shows that the security cameras have been disabled. You'll hear evidence about a satchel of money that Kirby commonly carried around, well known, was missing. and the .22 pistol that he commonly carried in his pocket was also missing. Ironically, 1 year later, November 30th of 2023, the Spences were arrested in Virginia by officers from Smith County. They found keys on Mr. Spence to several lockboxes, storage units, etc. And those lockboxes and storage units were searched pursuant to search warrants. And in those lockboxes, we contend were items that belonged to Kirby Carpenter. Jeff Spence had the motive. Jeff Spence pulled the trigger. Jeff Spence murdered Kirby Carpenter. His defense is he wasn't there. We will prove otherwise. Thank you.
And that concludes the opening statement from the prosecutor in that case. Up next, the defense counsel will deliver his opening remarks. We're going to squeeze in a quick break, but when we come back, we'll have that for you. Stay with us. You're watching Court TV Live, your front row seat to justice. Back to court in just a moment, but first, here's a quick look at some of the other cases that we're tracking here right at Court TV. In Florida, the penalty phase for Jose Soto-Escalera is now underway. A jury must recommend either life in prison without parole or the death penalty for the father convicted of killing his mistress and their unborn child. Court is currently on an extended break, but we'll get you back into that courtroom later this afternoon when court resumes. And in Tennessee, the state's case continues in the Baby in the River murder trial. This one is for Brandon Isabel. The new father is accused of fatally shooting the mother of his child and then throwing their 2-day-old baby into a river. And in Iowa, the state is expected to rest their case in chief today. This is in the machete murder plot trial. Dakota Van Patten is accused of kidnapping and then brutally murdering his friend's girlfriend. We'll keep you updated on all of these trials throughout the day here at Court TV. But for now, let's head back to Mississippi. This is for the plotting parents murder trial for Jeffrey Spence. So let's go back in now for the start of the defense's opening statement.
Good morning. Y'all are well this morning. Jeff Spence hasn't killed anybody. And he is chosen in this case. He's selected to be the criminal defendant. And because he's selected to be the criminal defendant, the accused person, the state of Mississippi has gone through all sorts of contortions and changes of pace, different approaches to make the evidence fit Jeff Spence. Kind of like trying to put a square peg into a round hole. That's what they've been trying to do for a year and a half. Mr. Mueller wants you to pay attention to the timeline. I certainly do. Spences were with their daughter in Tippah County for several months in 22. I'd been visiting there off and on for a year and a half or 2 years, but after the baby was born in July of 22, they spent much more time here helping their daughter in the first time developing mother and son. They were here until November the 29th, as Mr. Mueller told you, and they left at about 3 p.m. Where they live in Virginia, it's not an afternoon's drive. It's 10 hours. They drove 10 hours home. Wee hours of the morning they arrived. They get some rest. And the next day, they're doing things at their property, their home, that had been neglected for weeks. Spent the day there at their home. The government says, well, let me back up. This case is based on government theory, not government evidence. There is no evidence, none, zero, that Jeff Spence was at Kirby Carpenter's house on November the 30th. I don't dispute that that's the day he died. I just dispute who did it. Obviously somebody was there, knew that he would be there. Jeff Spence didn't know that. One of the things you're going to learn about Kirby Carpenter, you're going to learn a lot more than Mr. Mueller told you. He wasn't just a businessman and ex-Marine. He was a drug dealer, and he was a stolen gun runner. We get that from some witnesses right here. And when he was killed on November 30th, Jeff Spence was with his family, his wife, in Virginia, 10 hours away. The government's first theory, trying to put him in this square hole, said that, well, he never left. He and his wife didn't leave Mississippi. They went to Alabama, got a motel room, and came back. They couldn't develop any evidence for that, so what'd they do? They trashed it. And the next theory, not fact, next theory was that Mrs. Spence, who was severely ill, drove herself back to Virginia on November 29th for 10 hours. And that Jeff Spence stayed behind. Where? They don't have any evidence of where. They don't have any evidence at all. That's theory. And the theory is that he hid out and killed Kirby Carpenter. Now, they couldn't make that fly because if that were the case, Jeff Spence is standing up here in Nipton County, Mississippi, afoot, with no way to get back to Virginia. Well, that wasn't going to fly either. So they trashed it. Third theory is that he drove from Mississippi 10 hours to Virginia, wee hours of the morning, gets some rest, turns right around, and comes back to Mississippi for 10 hours. An almost 70-year-old man driving 20 hours and 24 hours. Hid out and killed Kirby Carpenter. And then 10 hours back to Virginia. It's not plausible. It doesn't fly. As they used to say in West Point, Mississippi, that dog doesn't hunt. That is not based on any fact. None. It's based on their theories trying to make a round peg go into a square hole. And it just doesn't fly. One of the things you need to know about Kirby Carpenter, and you'll get it from people on the witness stand. Kirby lived a very self-centered, independent life. Kirby lived life on his terms. He wasn't telling you where he was going tomorrow. He didn't want you to know his schedule. He didn't have a schedule a lot of times. And he was known.
All right, always the opening statements makes a case more interesting, learning a lot more about the background here. Let's take a break. We're going to have the remainder of the defense counsel's opening when we come back.
A tragedy on the Mississippi, a young mother executed
And her 2-day-old daughter allegedly thrown into the river.
Now the baby's father stands trial for double murder.
The Baby in the River murder trial today, only on Court TV.
The brutal murders of 2 young girls.
Delphi is not one of those places where this would happen.
I killed Abby and Lily.
Victim to Verdict with Ted Rowlands. Season premieres Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Before we get you back into the courtroom, we have a quick update on another trial that we are monitoring here at Court TV. This one is out of Memphis, Tennessee. Defendant Brandon Isabel is accused of murdering his child's mother, then throwing their 2-day-old daughter in the Mississippi River more than 3 years ago. Earlier this morning, the victim's mother, April Campbell, took the witness stand and emotionally recalled the day she learned that her daughter, Danielle, was pregnant. Take a listen.
Can you identify Brandon Isabel in the courtroom?
Yes.
Can you point him out for us?
Right here.
He's standing up, so I guess she's identified.
Yeah.
All right, that's the guy she started dating?
Yes.
Did you approve of that?
Objection, Your Honor.
She can say if she approved of it or not, Judge. None of this. It's her feelings about the relationship.
It's not relevant.
I think it is relevant.
Overruled.
Did you approve of her dating Brandon Isabel?
I can't say, well, to be honest, no.
At some point during 2021, Danielle becomes pregnant, right?
Right.
Do you remember when you learned about that?
I learned, I want to say in June or July.
How did Danielle, well, what did you learn? What were her feelings about that? Or do you remember what she felt about her pregnancy?
She was excited about Kennedy. She sent me a picture of her ultrasound saying, Mama, guess what they found? What they found? And she was like, they found a baby. I had to actually just look at the picture and see her name because I thought she was playing a joke on me. But she was really excited. Everybody was excited.
We will continue to keep a close eye on that courtroom and bring you updates throughout the day right here on Court TV. And you can also watch the Brandon Isabel trial streaming live on CourtTV.com. Meanwhile, let's go back to Mississippi, where it is day one of the plotting parents murder trial. This is for defendant Jeffrey Spence. Spence is facing murder charges after prosecutors say that he killed his daughter's boyfriend during a robbery. Let's get you back into that courtroom. We are listening to the defense's opening statement.
Kirby might leave tomorrow, come back Saturday. You never knew. He was that independent. He didn't want anybody telling him what to do. Just think about how foolish it is for the government to take the position on their theory that Jeff Spence would drive 10 hours to Virginia, 10 hours back to Mississippi. How in the hell is he going to see Kirby Carpenter? You know what Kirby Carpenter's schedule was. He's coming all that way just on the chance that he might encounter him. Does that make sense? I say no. No. And the government has Kirby's cell phone. The government has Jeff's cell phone, or had it. They do what's called an analysis of the phone. In my profession, we call it a dump. I mean, just downloading the information. And a lot of times it's thousands of calls, text messages, whatever. If you take that cell phone of Kirby Carpenter's and you analyze it, you'll see that there was no contact from Jeff Spence to Kirby Carpenter. You gonna be around? I'll see you there about 6:30. Okay. No back and forth. None. No communication. No evidence. Look at Jeff Spence's phone. You find the same thing. There's no communication. And they want you to believe, and we're going to nail this down with their witnesses, they want you to believe that he went to Virginia for 10 hours, drove back 10 hours, killed somebody, drove back to Virginia in 10 hours, all on the chance that he might encounter Kirby Carpenter. It just doesn't fly. Okay? This case went on for a year. The government didn't know who to charge. And they ended up charging the arrest warrant for Jeff Spence was November the 30th, actually 1 year after Kirby's death. And that warrant was, they hadn't developed any evidence of of Jeff's being president of Mississippi, back and forth, nothing. A couple things I want you to listen to. The warrant that was issued for Jeff's arrest was based on information that a career criminal named David Barnes conjured up to get himself some sort of break from the government, because David Barnes is a career criminal. He's facing life in prison. He's in jail in Tippah County right now with some special breaks because he's now their trustee. But David Barnes knows how the system is played. He's facing life imprisonment as a career criminal. Habitual is what we call it in Mississippi. And he gave a statement on November the 3rd, 2022, after he was arrested yet again for a series of burglaries, break-ins, and thefts. David has a fondness for stealing your stuff, selling it at a pawn shop. As a matter of fact, pawn shop is his nickname because that's what he does. He steals your stuff and sells it at pawn shops. And he'd already been to prison for doing that years ago. And he got arrested in 2022. Well, let me back up. He worked also. David worked for Kirby Carpenter. When Kirby was found, one of the first people that law enforcement talked to was David Barnes. David Barnes didn't give any statements about anybody. He just denied knowledge of everything. And then in 2023, David Barnes gets talked to again by Chris McAllister, Tippah law enforcement. Doesn't say anything about Jeff Spence or anything. He gets talked to again in 2023 about Kirby.
Let's go ahead and bring in trial attorney Krista Ramey. Krista, we're just getting into this case here at Court TV, and wow, lots of twists and turns, and hearing quite a story from defense counsel saying, hey, pay attention to the timeline. Just like the prosecutor said, I want you to pay attention to that timeline too. What do you think so far?
I think that I'm going to be paying attention to that timeline. It is hard to tell where this is going to go. It's very different than what I've read online in terms of, it seems like it's an open and shut case. I mean, his daughter is testifying, against him, for crying out loud. So, I think that we have a lot to learn and see what happens in this case. But it looks like they're going to be putting on a case.
Yeah, absolutely. And it's going to be interesting to hear what the daughter is going to say. I mean, you have to wonder. I mean, she was with this guy, and now defense counsel is talking about, we had heard when you read it online, Krista, he had dealt in precious metals. This is the victim in the case. But then you hear defense counsel really saying a lot of other things, that he was dealing drugs and lots of other criminal activity or alleged criminal activity.
Well, and he was known to have a lot of cash in his house, sometimes $200,000 or $300,000 at a time. I mean, this seems like something that would be right for, someone coming in and maybe, committing a theft and have it, die, someone getting murdered in the process, right?
Yeah.
And so I think that there is a lot to learn. Suspended sentence, so she's not going to see any jail. And so, it's going to be interesting to figure out what all happens here. But to testify against your own dad, might be some real evidence there.
Yeah, we'll have to see what she has to say. Krista, thanks. The defense counsel's remarks will conclude after we take a quick break. You're watching Court TV, your front row seat to justice. Stay with us. We're coming right back.
Try Dr. Marty risk-free for 90 days. Plus, get a free gift when you call or visit drmartypets.com/Caesar.
And welcome back to Court TV Live. I'm Kelly Craft along with Matt Johnson. Thank you for being with us today. We are in Mississippi this afternoon for the plotting parents murder trial.
36-year-old Kirby Carpenter was found shot to death outside his home back in 2022.
Now, prosecutors do believe that defendant, Jeffrey Spence, plotted with his wife Karen and daughter Caitlin to rob and kill the successful businessman who was also the father of Caitlin's months-old daughter.
Let's get you back into court now for the remainder of the defense's opening statement.
Kirby's case, again, doesn't say anything incriminating to anybody. Now, November 3rd of 2023, David gets arrested for 4 more break-ins. 4 more break-ins. And that's when David is savvy enough with the criminal justice system in Tippah County to know that, holy cow, I'm in a whole bunch of trouble. So David makes up a story about something that he heard at Kirby's funeral that Caitlin, David's cousin Kirby's girlfriend, something that Caitlin said at the funeral, incriminating herself and her father. It took him a year to come up with that. He came up with it because David is savvy at covering his tail end, so to speak, getting some sort of benefit, some sort of relief. I'll tell you a story about it in just a minute. And that's the evidence that they were flying on. When I got involved in this case, that was their evidence. It's what David Barnes said. David Barnes is not credible. He's simply not credible. And later, recently this year, Caitlin, who felt like she needed to get herself out of trouble, get herself back to her baby, gave a statement to law enforcement, and part of that statement was David Barnes is a liar. What David Barnes said, I said at the funeral home, is a lie. He's simply making it up. And that's in keeping David Barnes' personality, his temperament. When he gets himself in trouble, he tries to do something to alleviate the trouble. And I'll tell you this, David Barnes one time stole a church's money. He stole the money from the church in Park up in Tippah County. And to cover his tracks, to help himself out, you know what he did? He tried to burn the church down and burn all the evidence. He went to prison for that. The notion that you'll hear what Caitlin has to say, I'm telling you, it's all contrived to get herself out of the focus. She's the one who lived with her, not Jeff Spence, not Karen Spence. Caitlin was the one in the house. She was the one who was there. And she was in this house November 29th, 30th, December 1st, December 2nd. And for some reason it took her 4 days to go find, 3 days to go find Kirby's body. That's something you'll have to determine whether or not she's credible. But you will hear in this case evidence of text messages between Karen, the mother, Caitlin, the daughter, on November 30th, clearly putting Jeff Spence at home in Virginia. Not not in Mississippi. When he's in Virginia, he's cooking a meal for the family. He's not on his way to Mississippi. They want you to think he. 10 hours up, 10 hours back. No. On November 30th, Jeff Spence was at his home, taking care of his business, taking care of his relationship with his wife, minding their own business. And as we go through this case, bear in mind, there's no evidence, no hard, direct evidence putting Jeff Spence where they want him to be, where they're trying to make you think he was. No. Don't fall for it. They say that when they searched the safe deposit box in Virginia, they found Jeff Spence's collection of stuff. I mean, he's been, what Kirby was doing in terms of what I told you yesterday I call collectible, Jeff's been doing it since Kirby was not even out of diapers. That's how long Jeff's been collecting coins, medals, and that's it. Kirby was a baby. And they do find in this safety deposit box some things that Jeff had gotten from Kirby. He bought from Kirby. They did business together. Not all the time. Jeff did business with a lot of people. But he did business with Kirby, and I can't tell you exactly everything that's in that box that he had bought from Kirby, but he did. He had a relationship, a business relationship with Kirby, not just a family relationship. One of the things I want you to focus on is when Kirby's body was found on December 2nd, found by Kate on December 2nd. Law enforcement then floods the place. Okay. Chris McAllister, who was the case agent, I think, in this case, was a deputy sheriff investigator in Temple County. I think he's going to be the first witness. Kirby had a room in his house that everybody called the safe room. When I say safe room, I don't mean a place you hid when tornadoes come. A room full of safes. I don't know, a wall covered in safes. Had stuff in it. Now, if Jeff was the killer on November the 30th in the evening when he was at home in Virginia, and if what was in his safe deposit box came from Kirby, you would think that there would be some damage to those safes. Some crime, removal, breaking the locks. There's no evidence of that. Whoever killed Kirby wanted to kill Kirby. And Kirby, I told you, meth dealer, pill dealer, gun dealer. Kirby lived a high-risk and dangerous lifestyle. And he was in a dispute almost completely daily with somebody about usually money. He sold a liquor store to the guy, and I've subpoenaed that guy, but I can't find him. And that guy had made a verbal threat to Kirby shortly before Kirby's death. Kirby was threatened the year before by another county resident with whom he had a business dispute over $2,500. The guy threatened to shoot him in the face for crying out loud, or haul him out in the street in Ripley and beat him to death with his friends. Kirby had just recently, before he was killed, sold some lab diamonds, fake diamonds, to a Chattanooga diamond dealer and ripped him off, passed off the diamonds as real, and they weren't. He was dealing with meth dealers, even at his house at Lake Mohawk, at various parking lots. And he had a gang in Memphis that he dealt with regularly. So, pay attention to all these details. Just bear in mind that the government's burden is to prove to you that Jeff did business with Kirby. I admit that, he did. But business with a lot of people. Make the government prove to you that Jeff Spence was at County Road 600, Temple County, Mississippi, on November the 30th, at whatever time they say, 7 or 8 p.m. I can prove it to you, but not beyond a reasonable doubt and to your individual satisfaction. And I'll be revisiting all of these facts with you as we go through the witness. Thanks so much.
There you have it, David Hill with the defense delivering that all-important defense opening statement. And they don't have to prove anything, but it appears that they're going to put on a case. Let's bring in our guest joining us this hour from the great state of New York City, trial attorney Rebecca Woodward. Welcome to the program. What are your thoughts on this? A lot of Southern charm there in his seersucker suit, pointing to a lot of hot-button issues, including things in the community like theft and stealing from the church, and someone else did it. What stood out to you?
I mean, look, it is a defense statement. Basically, the gist of it was, let the prosecution prove that this particular man that they have on trial actually committed this murder. And he gave a lot of alternate theories on who else it could be. He also gave statements that he claims he will prove that this defendant, the particular man you're seeing in the courtroom right now, was not even in the state the day of the murder. He was home in Virginia cooking some dinner, and he was nowhere near the murder, the scene, the victim, nowhere. Then he starts telling the jury, now he's got to prove some of this, that the victim was a very high-risk human being, that he dealt in very high-risk situations, some drugs, some saying that he passed off diamonds that were fake as real, that he had a lot of cash on him all the time and was alluding to the fact that he was doing some sort of unsavory transactions on a regular basis, and he was threatened by numerous people, basically telling the jury, hey, there are a lot of other people the prosecution should be looking at, not my client. But what happens after an opening statement is that the prosecution will come up with their evidence. Now, the defense does not have to put on any rebuttal case because the prosecution has to prove beyond a reasonable doubt, which he did state in his opening statement. But if there's information that rebuts even this information from the opening statement that the defense has given, it'll leave the jury probably with concerns, questions, or conclusions. We have to see where this goes to see how far the prosecution can go to basically rebut all of the statements that the defense just placed into the jury's minds.
Yeah, and Rebecca, speaking of that jury, so there was a change of venue in this case. Defense counsel put forth a motion for a change of venue, saying his client could not get a fair trial in that county, and that was granted. So the jury that they have, I was just taking a look at the jury makeup. We have 10 men, 5 women, so that's who's going to be hearing the case. Who knows what the final will be, the final tally on that once they decide who the alternates are at the end of the case. So we'll have to see. But change of venue here, you don't always get that.
No, you don't. That's actually a very hard burden to prove, that in the community where the initial trial would have been held, that this defendant would not have gotten a fair trial. What the basis of that usually is that there has been so much publicity, so much information already put out, that the jurors will be biased in one way or the other towards the defense or the prosecution, and that doesn't allow a fair trial. That doesn't allow the jury to come in, sit down, and say, I have an open mind. I'm going to listen to the information the evidence has proven, and the judge will instruct me on the law. That is extremely important. In a criminal case, we want to make sure there's no bias in a jury's mind so that the truth, to the extent that we can get to the truth, that's what we're looking for. Justice and the truth in these trials. The prosecution and the defense do not want an unfair playing field because you don't know which way the field is tilted. If you think, well, everyone wants to set the defendant free, you might have one person on that jury that doesn't, and that is already has preconceived notions for the prosecution. So you really want to come in with a blank slate. You want a jury that doesn't know much about the case so that the jury can just listen to what they're hearing in the courtroom only.
Yeah, looks like that's what they have here. Rebecca, thank you so much. And before we head to break, we do have some developments in Kansas City, Missouri. This is a case we're following. Police are releasing details about a man arrested last week attempting to serve singer Taylor Swift with deposition papers.
That's right. Police arrested Justin Fisher after he allegedly jumped a fence and trespassed on the property of Kansas City Chiefs football player Travis Kelce back on September 15th. The newly engaged couple were believed to be home at the time. Fisher was arrested on a charge of misdemeanor criminal charge of trespassing and has since been released on bond.
And still ahead, the state's first witness takes the stand. This is in that plotting parents murder trial that we've been watching. We'll have a responding officer's testimony. That is coming up next. You're watching Court TV, your front row seat to justice.
8.5 months pregnant, a young mother found brutally murdered.
To lose a child, there's no words for it.
Now the victim's boyfriend, a married father of 4,
Guilty of first-degree murder in the death of his mistress, as well as their unborn child.
That's one of the things that struck me. He was not remorseful.
Court TV takes you inside the South Florida courtroom
where jurors will decide if he will be put to death.
The pregnant mistress murder trial, penalty phase. Live coverage today, only on Court TV.
Let's go back to Mississippi for the plotting parents' murder trial.
Jeffrey Spence is accused of fatally shooting his daughter's boyfriend back in 2022.
At the time of the murder, the victim, Kirby Carpenter, and the daughter recently had a baby together.
Let's get you back into court now, where the state's first witness has just taken the stand. This is an investigator who responded to the crime scene.
Chris McAllister.
And what do you do?
I'm an investigator with Tippah County Sheriff's Office.
All right, how long have you been an investigator with the Tippah County Sheriff's Department?
Over the years, nah, probably since 1995, off and on.
As an investigator or just in law enforcement in general?
In general, law enforcement, but at the same time, I pretty much investigated off and on my whole career.
All right. In Tippah County your whole life?
No.
All right. Tell the jury about that.
I've been there probably since 1991. My father was a preacher, and we moved around a lot. So.
Okay. So in 91, you moved to Ripley?
I believe that's correct.
Okay. Were you in law enforcement before then?
No.
How old were you in 91?
20. I'm in the thinking.
Didn't know there was going to be a man.
22. I think 22 or 23.
22 years old?
Yeah, 22 or 23.
And have you always been, when you got into law enforcement, with Tippah County Sheriff's Department?
Yeah, when I started out, I was actually in college and did an internship class through the Sheriff's Department. That's how I came to work here.
All right. How many sheriffs have you worked for?
I think 5.
Okay. Been involved in investigations most of that time?
Most of the time.
How many murder cases do you think you've investigated?
Myself, probably 8 or 9.
Okay. How many times have you ever testified in court on criminal cases like this?
Probably over 100 anyway.
Okay. Now, as well as being the investigator with Tippah County Sheriff's Department, what was your position in November of 2022?
Investigator.
Any other roles with the Tippah County Sheriff's Department?
At that time, I don't think so.
All right. After that, became chief deputy at some point?
Well, right now, I'm pretty much acting that right now.
Is that microphone on?
I don't know. It is. I hear it moving.
Can you get it a little closer to
I
it?
can. Is that better?
I don't know. All right.
I'll try to talk louder, sorry.
That's okay. All right. So, in November of 2022, were you also the coroner?
Oh, yes. I'm sorry. Yeah,
That's all right.
I was.
You coroner for Tippah County?
Yes.
How long had you been coroner for Tippah, or how long have you been coroner for Tippah County?
About 9 years.
Okay. Elected position?
Yes.
All right. What are your duties as a coroner?
To investigate deaths, determine the cause of death, and whether it was natural or not.
All right. If you're called out as an investigator to a death, how do you?
I try to keep it separate.
All right.
As much as I can.
Now, did you know Kirby Carpenter?
I did.
Prior to November of 2022?
I did.
How did you know him?
I just knew who he was, and he knew who I was. It was basically handshake, how you been doing, and that was about it.
Well, see, for lack of a better way to put it, well known in Tippah County and Ripley?
I'd say so, yes.
And why is that?
Because he did a lot of dealing in precious metals and had a little pawn shop. Well, he didn't like the word pawn shop, they said.
Yeah.
He had a store there in town that, on the square, that he did a lot of business out of.
Right across from the courthouse?
Yes.
All right. Did you run into him just like you would anybody that had a well-known, established business. And
Yeah, pretty much. Just might bump into him every now and then.
Did you know who his people were?
I didn't really know them.
Not at the time?
Not at the time.
Okay. Now, did you know prior to November of 22 any other ventures that Kirby Carpenter would have been involved in?
No, he had opened a liquor store up in Ripley whenever they finally voted liquor in.
So,
they did that for a few years, and I believe he sold the liquor store and then had bought another one in Boonville. And I think at the time he was killed, he had pretty much sold it also.
Okay. All right, now tell the jury about how you...
Setting the stage there for how this investigation started there. All right, coming up, more testimony out of Mississippi in the plotting parents murder trial. Also, we are going to keep you updated on the other cases that we're following here at Court TV. We'll get you back to court in just a minute, but first, an update out of the state of Florida where Jose Soto-Escalera is facing the death penalty.
The married father of 4 was found guilty last week of murdering his 23-year-old mistress and their unborn child. Now a jury must recommend if he spends his life in jail or receives the death penalty.
Earlier today, the jury heard from the victim's son, Tania Wise's son, who gave an emotional victim impact statement. Let's watch.
Hello, I'm Jamar, and I'm the son of Tania Wise, who was taken from us. My mother was the closest person to me, and she was like my best friend. Also, she was always there for me. I'm here to share a few to honor my mother and talk about how I was affected. Ever since that day, there's been many different, ever since that day, there have been many different ways that I've been affected emotionally. For example, I've developed depression, sleeping problems, and anxiety. Losing her made me grow faster than I should have. I used to hide my pain and try dealing with it on my own, and to protect myself from getting hurt more than I was. And I didn't like talking about what was wrong with me. Every day, I think about how she won't be able to see what I've accomplished and what I will accomplish in the future. She's already missed some of my milestones that I've reached, and I think that she would have been proud of them. I wish that she could have met my first girlfriend and watched me perform in my musical performances for my school. I'm in marching band. My mom was also musically inclined. She played the clarinet, and I hope that she would be proud of who I've become. On that day, I've lost more than a mother. I also lost the chance to have my mother watch me grow, and I hope that she's proud of me for coming here and talking about how this has affected me. I choose to honor my mother because she was one of the most, if not the most important people who has been in my life.
Court is expected to resume there at 1 p.m. Eastern when the defense will begin calling witnesses in the penalty phase of the trial. We'll take you there live as soon as court resumes.
For now, let's head back to the state of Mississippi, where at this hour we've been following day 1 of testimony in the plotting parents murder trial.
Defendant Jeffrey Spence is accused of murdering Kirby Carpenter at his home near Boonville, Mississippi. This was back in 2022. Carpenter shared a daughter with Spence's daughter, Caitlin.
Still on direct is investigator Chris McAllister. Let's get you back to court.
All right, now tell the jury about how you became aware that Kirby Carpenter had been killed.
I was driving to Walnut actually to pick something up on my lunch break. I received a phone call. I think I received 2, one from Keith Bullock, who was the school resource officer that day, and Sheriff Gillard had called me as well. They advised me I needed to come out to Kirby Carpenter's house. He gave me the address as soon as I, got back. So I finished doing what I was going to do, went back to the house, changed out vehicles, and then went straight out there.
Okay. Do you know what day that was on?
On Wednesday, it was on Friday, December the 2nd.
Do you know what time you got that call?
Sometime after 12:30.
Okay. So Friday, December 2nd, around 12:30, midday, you receive a call from Keith Bullock and Sheriff Gillard.
Yes.
And they notified you that Kirby Carpenter had been killed. Did you know where his home was?
I did not.
They gave you the address?
They gave me the address.
All right. And so you were on that Friday driving your washer to Walnut to get repaired?
Yeah, I was actually, my washing machine had torn up, and I went to Walnut. There's a store there that sells washing machines, so I went up there to pick a washing machine up on my lunch break.
You were picking it up, took it back home?
Yes.
Reported to Kirby Carpenter's home?
Yes.
Do you know that address?
Boonville, was going to be a Tippah County address. Some of the addresses out there are Ripley addresses, some of them are Boonville addresses, and some of them are Baldwin addresses. They several different.
When you're close to the line, sometimes they call it the address for a town that's in
close
the
by,
county.
correct.
But at that location, at that address, where you reported to, where you found the crime scene, was that in Tippah County?
It was.
State of Mississippi?
It was.
Okay. How long did it take you to get from when you received the call to when you arrived on scene?
Probably, just to estimate, probably 45 minutes.
Okay. Do you know what time you arrived at the scene?
I don't exactly.
Approximately?
One something, probably 1:20. I don't know for sure.
Okay. When you arrived, what did you observe?
When I arrived, several of the deputies were there. The sheriff was there. Several other individuals was present. I parked and walked up there. Told Deputy Bullock to kind of keep everybody at the bottom of the driveway. Went up there and talked to Carl Gillard, the sheriff. I think Josh Bateman was there, used to be an investigator with us. And a couple other people, they directed me over to where the body was.
Okay.
When I got to where the body was, I observed Mr. Carpenter laying on his back, had a curtain covered up over him, and a truck toolbox laying on top of the curtain.
Okay. I'm going to back up just a little bit.
Okay.
Were you able to, or were you aware that a 911 call had been made?
Yes.
All right. Were you made aware who made that call?
Yes.
And who made that call?
Caitlin Spence.
And when you arrived on the scene, was that person identified to you?
Yes.
So Caitlin Spence was there
at the scene, correct?
Okay. Your Honor, if I could have this marked for ID. Yes, sir. I'm going to hand you what's been, I'm sorry. I'm going to hand you what's marked as Exhibit 1 for ID.
Yes.
Recognize that?
I do.
Have you reviewed the contents of that
I have.
jump drive?
I have.
Does it accurately depict the 911 call?
It did when I listened to it, yes.
Your Honor, the state would ask this be received into evidence.
I'm not sure I know exactly what it is. It's
911.
supposed to be a 911 call. I have no idea.
Permission to publish.
Okay.
Everybody good on the jury? And I told y'all yesterday, if you ever need to break my attention, I meant it. I don't want anybody to unlawful, okay?
While they're setting that up, I want to review again with you who was present. Was Keith Bullock there?
He was.
And Keith Bullock was the constable?
Yeah, he is the constable, but he works as a school resource officer, a deputy through us, assigned to Pine Grove School.
So if you just explain to the jury, if a 911 call comes in, if somebody calls 911, where does that phone call go? And what happens from a law enforcement standpoint once that call is made?
Usually whenever they call 911, our phone system like backs up several seconds before it starts, answering. I don't understand how it does that, but it does. It goes into our 911 system. Once it comes into there, the dispatcher will give us all the call of what the best they can find out what's going on, and then dispatch an officer out to the scene.
Still with us, watching with you at home, is trial attorney Rebecca Woodland. All right, he mentioned it right there, that key piece of evidence, that 911 call. We know that that was made by Caitlin. I'm sure this jury's going to hear it.
Rebecca?
Yes.
Hi. Hi
So
there.
the jury will hear, not only will the jury hear about the 911 call, the jury will hear all that this man saw. Now, he is an investigator and a coroner. So in certain counties that are smaller, do double up the duties. This man is extremely experienced. From college, he interned at the sheriff's office. So he has over 30 years experience. He already testified. I have done this myself 8 or 9 times, which in small rural counties is a lot. There aren't a lot of murders in some small rural counties, but he said he's testified over 100 times. So not only has he investigated murders on his own, but he has contributed to over 100 investigations. So what the prosecution has done is establish him as a confident, intelligent, knowledgeable, and attempting to establish him as honest and very relatable to the jury. So by him saying, well, I went home and I was getting a new washing machine before this call came in, then this call came in that dispatched me to the location. They established the address, they established the location of the body and how he saw the body when he first arrived onto the property. And now we're hearing about the 911 call, which was allegedly, we'll find out now exactly, made by the deceased wife, which is the child of the parents who are, well, father on trial, mother already took a plea and will be in jail for 10 years on this. She took a guilty plea. Now we're just seeing the father on trial now. And this is important evidence to establish a chain of custody of the body, investigation, where the call came, what it said, how the investigators were dispatched, and now what they did from the point of time here, him arriving on the scene, thereafter, the coroner's result, the reports, how the body was handled, how long it was deceased, how this man was killed, and how the prosecution then will proceed to connecting that murder to this defendant that is sitting in the courtroom right now.
Yeah, that defendant sitting in the courtroom, we were just taking a look at him. And Rebecca, you mentioned his wife. So yeah, there's the defendant there. His wife entered into an Alford plea, and she said that, so this was to a lesser charge of grand larceny, accessory after the fact to grand larceny. So she's not admitting that she did that. She's just saying and kind of admitting that the state has enough evidence to prove that. So it's been an interesting case to watch so far. We're just getting in it here at Court TV, but we're going to squeeze in a quick break. We're going to watch more of it because we're just beginning to see how the state is building its case against the defendant. And you're taking a look at the victim in this case right there. We'll be right back.
A tragedy on the Mississippi, a young mother executed and her 2-day-old daughter allegedly thrown into the river. Now the baby's father stands trial for double murder.
The baby in the river murder trial today, only on Court TV.
The brutal murders of 2 young girls.
Delphi is not one of those places where this would happen.
I killed Abby and Lily.
Victim to Verdict with Ted Rowlands. Season premieres Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Welcome back to Court TV Live. Back to Mississippi. It is day one of our newest live trial. We're calling it the Plotting Parents Murder Trial. This is for Jeffrey Spence.
Prosecutors say that Spence murdered Kirby Carpenter, who shared a child with Spence's daughter, Caitlin, for money. But the defense claims someone else did it.
We hear it all the time. Let's head back into the courtroom now. We're about to hear the 911 call made by Caitlin Spence on the day of Kirby Carpenter's murder.
So the dispatch went out to anybody nearby as well?
Yes.
Is it your understanding that Keith Bullock was the first to arrive at the scene?
He was.
Law enforcement wise?
He was. The school's not real far, probably maybe a couple of miles from where he lives.
Okay.
Where Kirby lived, I'm sorry.
All right. You say that Sheriff Gillard was there when you arrived?
He was.
All right. Who is he? Who is he?
Carl Gillard, the sheriff.
All right. How long has he been sheriff?
I think this is fourth term.
Fourth term?
I believe that's right.
Had the scene been roped off already when you got out?
When I got there, it was.
All right. And you said that Caitlin Spence was identified?
Yes.
Were you able to determine her relationship to the victim as part of your investigation?
Yes.
Can you tell the jury who that is?
Kirby's girlfriend that lived with him.
All right. Were you able to determine how long she had lived there with Kirby?
I'm thinking since, and I may be wrong on this, it's several years.
Several years?
Several years, maybe 2019 for some reason I'm thinking, but I'm not sure.
Were you able to determine whether they had any children together?
Yes.
All right. How old was that child? And
I think the child was about 3 months old.
All right. What's the child's name?
Enola.
Okay. Were you able to identify Dwayne Jones?
Yes.
Who is Dwayne Jones?
Maddie Jane Jones, who's Kirby's mother. It's her husband.
Okay. And he was there?
Yes.
All right. Do you know how it came to be as part of your investigation that Dwayne Jones was present when at the time you arrived?
I was told later on by Maddie Jane that she had called Dwayne because he was a lot closer. She knew something was going on at Kirby's but wasn't sure what, and told him to get over there fast.
All right. So on the 911 tape, you're going to hear the dispatcher's voice, Caitlin's voice, and later on Dwayne Jones.
Yes.
Is it your understanding that he arrived during that 911 call?
Yes.
Okay. And Dwayne Jones married to Maddie Jones?
Yes.
And Maddie Jones is?
Kirby's mother.
Kirby's mother?
Yes.
Okay. All right. Play the first one. All right, before you play that, I wanted to back up. You had said something about when somebody places that 911 call, even before the dispatcher answers that call, the conversation, the phone call is being recorded.
Yes.
Okay.
All right, we're listening to that 911 call. That's the defendant's daughter on that call. We're going to say goodbye to our guest, Rebecca Woodland. More of this case coming up.
Yeah, that's right. More coverage out of Mississippi and the other cases that we're covering here at Court TV.
Jury is entering. All right, jury is present. We proceed with the defense mitigation evidence, and the defense may call its first witness.
Thank you, Judge. The defense calls Raul Banasco.
Mr. Banasco, if you raise your right hand, I'll administer the oath to you. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
All right, and you may inquire, Mr. Burns.
Thank you, Judge. Can you hear me, Raul?
Yes, I can, sir.
Okay, tell us who you are, please.
My name is Raul S. Banasco. I am a prison and jail expert who has been consulted to interview and give my professional opinion based on my experience in corrections and my education and training on this case.
You're on Zoom. Are you not in Florida?
No, I am actually in Austin, Texas today.
Are you working in Texas now?
I'm actually off for the afternoon, but yes, I do have a full-time employment, but I'm off for the rest of the day, sir.
Tell the jury about your education, please.
I have an undergraduate degree from Iona University in New York, with a focus on psychology, minor in criminal justice. I have a master's in public administration from Florida Atlantic University in Boca Raton, Florida. I also have my certification as a public manager through the Florida Atlantic University Master's Program, and currently hold my certification as a jail manager through the American Jail Professional Commission. As well, I'm a certified corrections executive through the American Correctional Institution Organization on Professional Standards.
Are you working in jail or prison administration now in Austin, Texas?
Yes, I am.
How long have you worked in that field?
I've been in this field going on my 39th year. Started my social services public safety career in New York, did 2 years with the juvenile system, and in 1988 joined the Florida Department of Corrections as a corrections officer at the prison now known as Central Florida Reception Center in Orlando, Florida. During my approximately 20 years with the Florida Department of Corrections, worked my professional development through classification. I served as a supervisor as well as a probation supervisor, an assistant warden at 3 major institutions, warden at a major Hernando correctional institution, also served in the capacity as the director of training for the entire Department of Corrections for 2 years, and then transitioned into jail operations. I served as the major for the Orange County Jail in Orlando, the deputy chief and interim chief for Osceola County Corrections, and then retired from the Florida system, did some nonprofit work for 2 years, and then have ran jails in different states from San Antonio, Fort Worth, St. Louis, as well as now Austin, Texas.
So you have worked in corrections here in Florida?
20 years, yes, sir.
Are you familiar with Florida DOC policies and procedures?
Yes, I am, sir.
You're not here out of the goodness of your heart, are you? We're paying you for this work, correct?
Yes, sir.
How much do you charge per hour, sir?
My fees are $200 an hour to interview, review records pertaining to any case, as well as $225 an hour for testifying, and $110 for any travel time involved on any case.
How many hours have you put in on the Soto-Escalera case?
16 and a half hours.
Is this your first time testifying in court, sir?
No, sir.
Where have you testified before?
I have testified in a variety of states, particularly in Florida. I've testified on various cases from Dade County, Duval County, Lake County, Marion County, Volusia County, Lee County, Gadsden County, also in the Panhandle, some of the Washington County, a variety of counties throughout the state of Florida, as well as done work in South Carolina, Louisiana, Georgia, Tennessee.
Do you testify always for the defense?
Yes, sir.
Has any state attorney's office, whether this one or anywhere else, ever used you as a consultant or consulted you on a case?
Not as a consultant, no, sir.
I'd like to talk to you, sir, for a moment or two about what life without parole would mean for an inmate so sentenced. Are you qualified to answer questions in that regard?
Yes, I am.
A person sentenced to Florida Department of Corrections to life without the possibility of parole, where are they housed? How are they housed in the system?
The way the process goes in the Florida prison system, like many, they are sentenced to a reception center in which they will go through 6 to 12 weeks going through a battery of assessment processes for mental health, medical, classification, custody review, and they're sent to a permanent facility. An individual who's sentenced to life will always be close custody. They will be sent to a facility that has that security level. Their requirement, once they are transferred to that permanent facility, they will go through an assessment process through classification, known as the institutional classification team process, in which they will be assigned a job. Every inmate who's serving life at a facility designed, they are required to work 60 hours a week. They are required to show up to work in addition to other obligations. They will be housed in a custody level, as we know as H4 or H05, which means their housing facility assignment will be either with another inmate or several inmates, and after dark, they are secured behind 2 or 3 additional secure doors to ensure that that custody level doesn't have access to the compound as a whole. In addition to working 60 hours a week, they're required to get up at 4 o'clock in the morning. They're required to march down to the chow hall, eat their meal within 7 to 10 minutes, return back to their assignment. They go through vigorous requirements. They get counted several times a day. They're told where to go, when to go. They have appointments to be at, and they are required to follow all the rules and regulations that the prison requires of them in that environment.
Is a prisoner serving life without parole, does such a prisoner shower every day?
Shower every day. They are given the option to shower in the evenings when the showers are open, but that is a communal shower environment in which they share in normal dormitories the ratio of maybe 15 showers for 250 inmates. There is a period of time in which the showers are open, and they have to take advantage of it. If they're not in that environment at that time or overslept, they just are not showered. They're also required to go to call-outs and have other obligations in which, when it comes to either the environment, TV, they share one communal TV per pod or per unit, in which they all have to decide what channel. So there's nothing individually catered to that individual inmate serving life. They have to share it with anywhere 70 to 150 inmates in that environment.
You indicated, I think, that a typical inmate serving life without possibility of parole is required to do work?
Yes. Every inmate, whether you have an impairment, you can be a wheelchair, medically declining individual, everyone is required to have a job assignment. It can be assigned as a houseman, and in this case, most of those who are healthy, they will be given an inside grounds job, which basically means they're given manual lawnmowers, they cut grass. We're talking big acre properties within the fence line. They also prepare meals. They keep up with the day-to-day maintenance concerns if you have any skills in maintenance, painting, repairing sidewalks, landscaping, keeping the upkeep of the prisons of these aging prisons, they're required to work 60 hours a week at their job assignment.
And a lot of their work is done to maintain the prison that holds them.
Correct. Basically, in the business of prison world, 85% of prisons upkeep are done by inmate labor and utilizing them to keep the facility operating.
So prisoners assist in cooking and cleaning and repairing and mowing grass, you said?
Yes, sir. They prepare meals, they launder the clothes, they paint the buildings, landscaping, and any kind of repair of plumbing or framing or any kind of construction repairs that need to be done within the business.
What if the inmate says, no, I'm not going to do this work? What happens?
What happens when any prisoner or inmate refuses to work, they will get a disciplinary report, which basically is a rule infraction. Refusing to work, and what the process is, if you refuse to work, you get placed in administrative confinement, as we often know in the business as the whole, the confinement unit. You will go through an administrative process in which the individual inmate being charged with the rule infraction will have an opportunity for it to be investigated based on the officer's report. They can call witnesses. At a period of time, they will come across the disciplinary board, which is 2 members and sometimes 3 members of the institutional classification team. At that time, they will plead their case, and that team will make the decision with what the outcome is. And in most cases, you're found guilty and you're given a sanction of time in disciplinary confinement. And in many cases, additionally, they will take gain time. And what happens is the individual will remain in disciplinary confinement with no privileges, no access to anything but his legal paperwork, and based on their behavior while in disciplinary confinement, they will be reviewed weekly, and eventually, if they meet all the expectations, will be released back to open population.
Let us talk about inmates who are not sentenced to life without possibility of parole, but who are sentenced to death and are awaiting their executions on death row. Can you describe a death row cell to us, please?
Yes, and those, if I could digress a little, those who are sentenced to death go through a different process. They will be normally taken to RMC in North Florida, get processed within a couple of hours, when they're taken to either Union Correctional Institution. An inmate who is sitting on death row, the environment is slightly different. These are individuals that are housed alone in a 6x9 cell with their assigned toilet and stainless steel sink. They are permitted to have their own TV in their cell. They are not required to work, and they are not required to leave their cell. The meals are brought to them. Their laundry is brought to them. They have changed things on death row in the last 2 years, in which now inmates on death row have more time outside of their cells. They have visits with families. They have a tablet assigned to them where they can communicate with their family. They have day room time in which they can interact with other inmates on death row, as well as have additional recreation time outside of their cell as well.
When a death row inmate is permitted time out of his cell, does he share that time with other inmates? Is he by himself? Tell us about that.
No, he shares it with several inmates, 5 to 6, 7 inmates, when they're in their day room time, so they're in contact with other inmates on the same status on death row. Recreation, they also have access to other inmates playing basketball and having more out-of-cell time with other inmates in their same custody level.
Why are the inmates sentenced to death? Why don't they work?
The requirement is that those individuals, because of their custody level, there's very limited work assignments, and because of security grades, the expectation of the high risk, those are individuals that are classified at maximum custody, and these are the individuals, because of their sentence, have to be watched at all times and placed in a secure environment. Giving them work assignments, it's not conducive to that environment. Often they can help out if they want, but they're not required. because of their custody level and the security aspects that go with it and supervising them.
Regarding death row, is there just one death row in one Florida prison and all those awaiting execution are there?
Yes, for the men, it's Union Correctional Institution, and for the women, it's at Lowell Correctional Institution.
How many are presently on death row, do you know?
Currently, approximately 458 are on death row as of today.
It seems to me there have been a great number of executions so far just this year. Do you know how many?
I think approximately 12 this year. The 13th is scheduled for sometime this month, and the next one is tentatively scheduled in late October this year.
So there have been more executions than months in the year so far.
Objection as to relevance?
Yes.
I was not the one who contacted you initially on this case. Who contacted you regarding involving you in this Soto-Escalera case?
That was back on June 3rd. Sherry Schwartz, Dr. Schwartz, who's a mitigation specialist, reached out to me.
So she knew of your reputation and work in this field then?
Correct. I worked with her on some other cases.
What were you requested to do?
I was requested to review all his corrections records, whether at the county jail, if he had any kind of prior prison involvement, review his assessment, have an in-person structured interview, assess the records that were provided to me, and give my professional opinion on how his adjustment has been while he's been in a corrections environment, and in this particular case for the last 7+ years.
Do you review records? What do you do?
Yes, I review records. I reviewed in this particular case over 220 records, pages of records that were provided to me for the St. Lucie County Sheriff's Office jail operations based on his state since he's been assigned. He's been booked there.
Did you get a chance to meet with or speak to Jose at any point?
Yes, I met with him on August 1st of 2025 for about an hour and a half at the St. Lucie County Jail, in which I had an in-person structured interview to meet with him.
Has Jose been in the St. Lucie County Jail since September 2018 consistently?
Yes.
Did you review any disciplinary reports regarding Jose Soto-Escalera from the St. Lucie County Jail during his 7 years of incarceration?
Yes, I did.
How many DRs or disciplinary referrals did you see in the records?
He technically had 3, but the way some jails do it, they lump them together. He had a disciplinary report back in 11/14 of 2019, and it was for unauthorized area while count, in which basically he was found guilty of that. Basically, during the count time in which they account for inmates, he was not where he should have been. They accounted for him, but he was not in the assigned area, in which they keep 30 days probation, which basically means don't mess up again or we'll take your privileges. And then in April 24th, 25, he had taken a table and some chairs to his cell, and when they were getting ready to lock down so he can play cards. So they actually wrote him up for having a plan and causing a disturbance to operations, in which he shouldn't have done it, but unfortunately he got caught and he was given a disciplinary infraction, in which he pled guilty to.
Any disciplinary referrals regarding fighting, violence toward other inmates or towards guards?
No, none of the records provided to me show any incidents or anything relating to any kind of violence, either with other inmates or with any of the staff or the corrections officers.
Do you yourself speak Spanish, sir?
Yes, I do.
Did you talk to Jose in English or Spanish or both?
I spoke to him in English. He speaks Spanish. We might have said a few words in Spanish, but Everything was English-based, the interview.
Based on your training and years of experience and having reviewed the records, is 7 years of incarceration consistently sufficient for you to review Jose's situation and render an opinion about his future behavior while in custody?
Yes, sir. 7 years is a good amount of time in which someone who comes into a jail environment, corrections environment, to assess them based on how well they adjusted to the environment, both from a medical, physical perspective as well as behaviors. Yes, sir.
And what did you conclude specifically then about Jose Soto-Escalera's suitability or unsuitability to be a prisoner?
What I assessed based on my years of experience and training, here you had an individual who was booked for a crime which was well publicized. The individual has been at the county jail, which, understanding the county jail environment and the prison environment sort of has its differences, where county jails have inmates that come and go every day, from misdemeanors to major felony cases, where the population in the county jail is very fluid. Didn't see anything in his records that show that he had to remain in protective custody. Didn't see anything in his records that gave the impression or alluded to him not adjusting well. He followed all the rules. 7 years, he did receive 2 DRs. They were not major DRs. In fact, one was just getting probation. So at the end of the day, someone who's sitting in a county jail for 7 years with a fluid inmate population, where in that environment, inmates tend to try each other. They're either victims or victors. At the end of the day, he steered away from that. The records indicate he followed the rules. He stayed out of everyone's way. He didn't cause anyone any kind of challenges. And he's adjusted well in the prison, in the jail environment, which would indicate someone like him, when sent to prison, will adjust well, stature-wise, behavior-wise. He will follow the rules and regulations in that environment without any concerns, based on the records I reviewed.
When you met with Jose, did you have a chance to discuss his work history at all?
Yes, I did. Had the opportunity, part of the structured interview, talk about education, in which he told me he did not obtain his high school diploma, but he did obtain many other trades. He has experience in the carpentry field, profession, construction, laborer, framer. Some of the skills that he's mastered in the construction environment was something he was very well versed and knowledgeable and had work experience in.
Do any of those skills and abilities equip him to be a useful worker as a prisoner?
Someone like him, based on my many years of experience, particularly classification, when they come to the reception center and end up at a permanent camp, what they do is they interview him based on his skills, because unfortunately prisons are, getting old and aged. So basically we assign work assignments. So every prison has assignments for carpenters, electricians, painters, general maintenance. And someone like him, who after a period of 60 to 90 days, who has done the entry-level jobs such as inside grounds in the heat, and they've proven to be a good worker based on the review we'll get it every week and every month by the officers, will be basically assigned an assignment such as maintenance, so he can use his skills to help the upkeep of the prison. And basically it's an opportunity for the prison system to have labor, free labor, at the expense of the inmate being held accountable to perform those duties based on the need of the institution.
Did Jose's charges and current placement at the jail for these 7 years render him ineligible from participating in jail educational programs?
Based on the records I've seen, and because when you have cases like this, based on the category classification level, which he's at the highest level, they do not, most jails like St. Lucie do not offer them the opportunity to have those education programs. And most likely, when he goes into the prison system, that will be the same approach. The investment, if sentenced to life, will not be For someone like him, they will utilize him for labor and what he can help is sweat equity and keeping the prisons upkeep.
So I'm not sure of the answer. Could you, Captain, clarify that? If it's a yes or no, I'm not sure what the answer was.
Did you hear the judge?
Repeat the quote. Judge, Your Honor?
Yes. Could you clarify as far as how it's been in the jail and what it would be like in general population? It seemed to me that you were equating the two, and then there was a difference between the two. I wasn't sure what you were saying, what it would be like in prison and how it's been in the jail. I want to just clarify your answer.
Okay, Your Honor, so to clarify that, so in the jail environment, there's a lot of moving population types. So when I was referencing that, was based on his adjustment in the jail environment. Most inmates who are in the jail environment for a long period of time sometimes fights and have aggressive behavior based on the type of inmates that come in and out of that jail environment. Based on his 7 years, he's adjusted well, which based on my experience, someone like him who ends up in the prison system should adjust well. The only difference in the prison environment, Your Honor, is those individuals are actually assigned to that prison for several years, and we assign them based on their labor skills and what they can do to keep the facility operating. Does that answer your question, Your Honor?
Thank you.
As long as Mr. Burns is comfortable with the answer, that's fine.
Yes, that's all right. Thank you, Judge. Now, I think you may have answered this question already. If this jury recommends that Jose be executed and that's what the judge orders, I think you said he would be welcomed into the system at the North Florida Reception Center and then he would go immediately to death row in Union Correctional. Is that correct?
Correct. It's normally done within several hours. They basically process them and move them into death row status.
And if Jose was sentenced to life without parole, where would he go? Do you know?
Because in St. Lucie County, he would go to Central Florida Reception Center. There's actually 4 male reception centers. He would be transferred to the reception center in which he will remain there anywhere from 6 to 12 weeks as he goes into the assessment process. And based on his medical grade, dental grade, psych grade, his assessment classification, as well as his security level, he will be assigned to a permanent prison throughout the state of Florida, either, and most likely will be in North Florida, where we have most of the prisons that house life inmates.
Now, in reviewing your notes here, I see that in Florida Department of Corrections, there must be facilities that are characterized as faith and character facilities. Is that correct?
Yes, they're known as faith and character-based facility, and often some of them are also in conjunction with incentivized prisons as well.
And would Jose be a good fit for a faith and character facility?
The criteria for that is something he would have to earn. You have to have anywhere from 24 to 36 months in the prison system without any rule infractions, any kind of violence, in which at that point, wherever he's assigned, he can put in for that. But that goes through an assessment process, through classification, and gets approved all the way in central office. So it's something that he would have to earn and not automatically considered for.
So you have reviewed Jose's records, you have met with him, you have the experience and education that you have told us about. Do you believe that Jose could contribute and be a contributor, even if it be only to the state prison system, if he were sentenced to life without parole?
Yes, yes, sir. Yes, I do.
The jury has been told by authoritative sources before, but I'll ask you also, does life without parole mean life without parole in Florida?
Yes, everyone, because parole doesn't exist since the 80s. Every inmate who was sentenced to the Department of Corrections with life without parole will never leave the prison fence line unless they're required to go out for a medical run, in which the proper security components Other than that, they would expire their life in prison and be removed in a body bag, sir.
Thank you, that's all I have for you.
Cross-examination?
No questions from the state.
May Mr. Banasco be released at this time?
You may, Judge. Thank you, sir.
You're welcome. All right, I'm going to end the Zoom, sir. Thank you.
Thank you, Your Honor.
You're welcome. Are there other Zoomers or?
No, I have one person live.
Okay, so
We have her
I
son
will
from
end the
Hawaii.
Zoom then. Okay. End the Zoom. And did you need a break at this time? Or?
No, we can proceed unless
Okay.
the jury needs a break.
Does jury need a restroom break? No, we're good? Okay, you may call your next witness.
Is Lucinda Cook? May we have her?
Sure.
Summoned from
Lucinda
Hawaii.
Cook.
Cook.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
That was your witness.
And you may inquire of the witness, Mr. Burns, when ready.
Thank you. Sit real close to that microphone in front of you, ma'am. Tell us who you are.
I'm Lucinda Cook.
Speak up nice and loud. Who are you?
I'm Lucinda Cook.
Okay, Lucinda Cook. You see Jose there?
I do.
How do you know him?
I used to date him many years ago.
Can you give us a time frame?
2006, for about 4 or 5 years.
2006 to 2010, 2011, somewhere in there?
12, yeah.
And how well would you say you know Jose?
I knew the man that I was with back then very well.
You know that he has now been convicted of murdering a lady and her unborn baby, correct?
Yes.
And you're not here to quarrel with the jury about that.
No.
But is it fair to say that you do not recognize that murder in the Jose that you knew?
Absolutely not.
What were your circumstances when you met Jose?
I was just getting out of an abusive relationship, a 10-year abusive relationship.
Did you have children?
I have 3.
How old were your children when you met Jose?
4, 2, and a newborn.
How did you meet Jose?
A barbecue, a friend's barbecue.
And was it a slow developing relationship or swiftly developing?
I mean, both. I mean, we dated for a year before we lived together.
Did you live together for that 4 or 5 years?
Mm-hmm.
Yes, say
Yes,
yes
yes,
or
I
no.
did.
Okay, thank
Sorry.
you. Just so the record has it.
Yes.
Everybody knows what you mean, but the record needs to be clear. And you were about how old then when you met Jose in 2006?
24, 23.
When you were with Jose, how was he with your young children?
He loves children. He was very good with them.
And how did your children react to Jose?
They liked him as well.
How did you feel being in a relationship with Jose?
I was just getting out of an abusive relationship, so I wasn't very nice to him. But he did everything he knew to do to display a great characteristic of a man that my son should look up to.
Did Jose make you feel safe coming out of that relationship?
Absolutely.
Sorry, could not hear the answer.
Absolutely.
Your children also?
Yes.
You indicated that I think maybe as a result of where your head was at coming out of that relationship, you said you were not always very nice to Jose?
I was not nice to the man at all. Sorry.
You were mean to him, I think you characterized it. Is that correct?
Yes.
How so?
Everything was worth an argument. Everything he did was wrong. I pushed his motorcycle down the driveway. I spit in his face. Told him to leave.
When you had disagreements and arguments with Jose, did he get violent with you?
Never, ever.
I
didn't even get an argument out of him.
I think you just told us in one of your disagreements you spat upon him. How did he react to that?
Just wiped it off.
You mentioned a motorcycle. Jose had a super duper tricked out motorcycle, yes?
Yes, sir.
Paint job, lots of chrome. He loved it. What did you do to it?
Pushed it down the driveway.
Because you were angry at him?
Because he wasn't moving fast enough. I was really mean.
I'm sorry. I think you was that toward the end of the relationship. You had enough. You said you'd go, but you punctuated that request by damaging his motorcycle.
I was just mean, and he wasn't moving fast enough. I don't know.
What did he do?
A lot of years ago.
What did he do when you did? Did he see you damage the motorcycle?
Yeah, he was right there.
What did he do to you?
Nothing. He just picked up the motorcycle and drove away.
So, despite provocations, you have not ever seen Jose to be violent? Is that so?
I've never seen the man be violent, and his occupation was a bouncer. I never even seen him fight a man.
And even when he was working security at clubs, he wouldn't fight?
Never. He was like a clown.
But there were other women in Jose's life, correct? And that's kind of why you ended it with him.
I just had a drama-free life, and the extra drama from having multiple kids' mothers. I just didn't want my kids to witness it.
Yes, one or more of Jose's other women would occasionally come around and interrupt your life. Is that correct?
Because of their own problems, not necessarily my problems.
Would you describe Jose as easily excited and angered, or a calm person?
I'm not sure that I've ever seen him super angry, not to a violent state. I mean, mad at something, work or something, but not angry enough to do something.
You know, earlier today I told the judge, and then later I told this jury, that a lot of witnesses I was counting on didn't show up, but you are here. Why have you come?
Joselito did everything during our 4-year relationship that he should have to display great characteristic of a man for my children. He would, an example of a man that I should have probably treated a little better. And I was just, I can't sleep at night knowing that he's gonna lose his life. And I was so mean to him for no reason at all.
Well, we don't know that yet. Do you want him to lose his life?
No.
Thank you. That's all I have from you, man. Thank you so much.
Cross-examination?
So let me just figure out the timeline here. It sounds like you started dating the defendant in 2006, is that right?
Yes, sir.
And then you broke up with him in 2013?
Late 11, 12, yeah.
2012? Okay. And if I understand correctly, you used to work down here at the gas station located at Midway and Selvets, right?
Yes, sir.
Okay. And you used to see the defendant every once in a while when he'd come into the gas station, right?
Yes, sir.
And if I recall correctly, you did not speak to him when he came in.
I never spoke to him again until recently, after I left him.
Right. So when the defendant would come into the gas station, you ignored him?
And treat him like a stranger.
And treat him like a stranger. Is that right?
Yes, sir.
Okay. So, and then from 2012 up until just a few weeks ago, you didn't speak to him at all.
Absolutely not.
Right. So 13 years went by,
and you didn't speak a word to it?
Absolutely.
Is that right?
Yes, sir.
Okay. And then when you did speak to him again just a few weeks ago, was that after the trial started?
I'm not sure. I didn't follow it or his situation. I've been getting phone calls from his children trying to get me to talk to him, but I didn't know why. I didn't know, I didn't follow. I don't watch TV, so I didn't know what was really going on. And I prayed on it for a while before I made my decision to help him.
Okay, but you said you spoke to him for the first time after 13 years a few weeks ago.
Mm-hmm.
So my question is how many weeks? 1 week, 2 weeks, 3 weeks, 4 weeks? How many, what would you say?
Let's go with a month. I don't know. I wasn't really recording dates. I didn't think I was.
A month. Okay, gotcha. And a lot can change with somebody after 13 years, is that right?
Absolutely.
Okay, all right, no further questions.
Thank you.
You redirect?
No, Your Honor. Thank you.
Okay. May Ms. Cook be released from subpoena if she is under subpoena at this time?
Yes, sir. She's on the speech.
Any objection?
No
Thank
objection.
you, Ms. Cook. You're released from your subpoena at this time. You're free to stay or leave as you wish. And counsel, if you want to approach.
Thank you.
Members of the jury, as I told you this morning, we're going to have a short afternoon. Those are all the witnesses for this afternoon. We are going to restart tomorrow. There's some work we need to do outside of your presence, so we're going to ask you to come in at 9:30, not 8:45. Gives you a little extra time, but we are still on course to get the case to you tomorrow afternoon. Please remember, of course, you know what I'm going to say. We're very near the end of this case. We're going to be recessing for the evening. Don't discuss the case with anyone. Don't do any research. Avoid all of the media coverage of the case. We're almost there at the end of the case. And enjoy your evening. Leave your notes on your chairs, and we'll see you in the morning, 9:30. Any other issues for us to address before we break until the morning?
No,
Any defense? All right, we'll see you in the morning. The interpreter is going to be here at 8:30 to assist you all. I'll be here at 8:45, and then the jury's coming at 9:30, so we're on track. And we'll see you in the morning. Enjoy your evening.